concerned with petition number 3180 of the 2024, because there is the urgency. This case was related to one teacher of LP school teacher who was appointed on 6/12/1990.
That is civil bench 2. This is not, this is bench 3, service matter. Service matter of school teachers is civil bench 2. You mentioned it before that one.
Is service matter or my
No, but school teacher,
Yes.
bench 2.
Lordship, I beg to mention item 6 of today's list. Lordship, I have informed the other side. Lordship, can this matter be taken up on the 8th, Lordship? I am awaiting written instruction, Lordship, because of which I am just seeking an accommodation. I have informed the other side, Lordship.
Item number?
Item number 6.
Item 6. On the request made by Mr. H. Aliha, Counsel for Respondents 2 and 3, matter stands deferred. We listed on 8th
Lordship,
of June. Please submitted that consent of the council to the petitioner has been obtained.
Lordship.
May it please your lordship. The lordship yesterday I mentioned a matter because of our delay in providing the filing number. So the filing slip could not be proceeded further. Today I'm ready with the filing number, lordship. Can it be today or tomorrow as your please? Lordship?
Friday?
Tomorrow, lordship.
Why? What is the urgency?
Because the order will be passed
What
without
order?
my representation.
What
The
order?
lordship has already, only one date has been the typical error in
Okay.
our tomorrow, lordship.
Tomorrow.
I'm obliged, lordship.
May I please your lordship?
Will come for orders.
It will come for order.
May I please your lordship? Lord, I beg to mention for listing of the matter. Can it be on Friday?
What matter?
This is the non-declaration of result of interview of the the Gauhati.
You are filing a fresh writ petition.
Right.
When was it filed?
It was filed on 26th of May.
All right, Friday.
May please your lordship, I beg to mention for listing of the writ petition. It was last on 27th of April, and it was supposed to be listed after 2 weeks as per order. Not been listed yet. Matter pertains to an Anganwadi worker's appointment, your lordship. May come up on Friday.
Meeting can't be on Friday.
Thursday also.
Appointment.
Appointment. And moreover, that same
What about the pleading? What about affidavits? Everything exchanged?
everything exchanged.
Exchanged. Right. Let it be on 11.
Deeply obliged. May I please? Lordship, it is a joint prayer, Lordship, in respect to item number 28. Lord. Petitioner is also here. Can it be taken up after 2 weeks, Lord?
28.
Yes, Lord.
Why 2 weeks? Let it come after vacation. Who's for the petitioner?
Lordship.
Let it come after vacation. Item 28 on joint request stands deferred to be listed in the month of July on a date to be fixed by the registry.
Hello.
Yes.
I get to mention for listing method. Friday, maybe listed on Friday morning.
What is the matter?
Compassionate level.
Compassionate appointment. Let it be on 8th, Monday.
May I please, lordship? I beg to mention for listing of a writ petition, your lordship, relating to regularization of service.
When was it last listed?
Last listed 6/11/24.
Why are you making a mention? Let it come after in July.
Oh, your lordship.
Why? 6/11, you are making a mention now before holidays. Why? What were you doing for all these months? List in the month of July on a date to be fixed by the registry. Registry will give you a date.
Within 15 days, your lordship.
No. See, you have to give a reason. From November, it was not listed. Suddenly, you wake up and you want to make a mention within the next 2 weeks. Why? Why? You can wait. Let it come in July. We'll take it up after you. All right.
Service benefit.
Service benefit. Service benefit. When was it last listed?
25/9/25.
Service benefits. 15th of June.
May I please, your lordship? I beg to mention item number 30. We were supposed to file affidavit. We have filed the affidavit, but it has not come to the record yet.
Who is we?
H. Gupta.
Oh.
I am for the petitioner, madam. I'm challenging a transfer, my lord. The child of the employee is 85% disabled, my lord. The file on affidavit, my lord, I have received the copy last evening.
So you have a stay order.
Yeah, I have a stay order.
Then
then it is not on record, madam, we will also like to file a reply.
Let it come in July.
Yes, madam.
Matter be listed in July on the request made by, on behalf of Mr. H. Gupta, learner CDC. It is submitted that the affidavit was filed yesterday. However, the same is not connected to the case record. Stock registry will verify and trace out the affidavit and connect it to the case record. Matter be listed in the month of July on a date to be fixed by the registry. Interim order passed earlier will continue.
May please, your lordship. Lordship, paying for listing of an IA, your lordship. Because lordship, the writ petition, no lordship has passed lordship the interim on, notice on interim lordship. But they have already started a process for DPC lordship.
Oh.
Lordship, I'm praying some urgency.
When is the returnable date? In the
Lordship,
writ petition?
returnable has already gone, lordship. They have taken time for file affidavit of opposition, but till the affidavit of opposition is not yet filed, your lordship.
All right, 15th.
Lordship, there's some urgency because.
15th?
No, lordship, I'm praying for Friday, your lordship, this week, lordship.
Why?
Because already the letter were circulated to collect all the ACRs and APRs from all the eligible.
Well, it is
candidates.
not going to happen like that. When was the letter received?
It was 27th of May. I have received it was circulated to the principal. I am the faculty member. It was circulated to me recently, lordship. Then I came before your lordship.
Principal of?
Principal of Regional Dental College.
Is it
And I am the faculty
education
member.
matter?
Lordship?
Is it before the education
No, no,
bench?
lordship. It is service matter.
All right, 8th of June.
It's Monday, lordship. It cannot be Friday.
No, why Friday?
Lordship, because lordship, there is a chances, your lordship, by this week they will send all the ACRs to the PMA, lordship. And
Has the DPC been constituted?
lordship,
DPC has been constituted.
lordship, not considered, but they have started collecting all the documents, all the.
They will come on Monday.
Right, lordship. Much
Yes.
obliged, lordship.
May I please? Lordship, I beg to mention pending cases, Lordship, for listing.
Early in July. Let it come in July.
Can you, prior vacation, Lordship?
No,
in
why?
any date,
Why?
Lordship.
Why? What is the urgency?
Lordship, urgency, Lordship, the Honorable Supreme Court has recently passed judgment, Lordship, whereby was and set aside the Upenda's judgment, Lordship, case relating to regularization, Lordship.
Upenda's judgment.
Yes,
Upenda's has been set aside.
yes,
All right. Then,
recently, Lordship.
do you have a copy of the judgment?
Yes, Lordship.
Give it to the court master.
I have one copy, Lordship,
Hmm.
but definitely will be one other.
What are these matters?
Matter pertaining to regularization and other benefits.
So, other benefits.
Yes.
All right, 16th.
Your Lordship,
16 June.
deeply obliged.
Item number 16, an affidavit in fact, can you allow me?
Item?
Number 16, Lord.
Ah.
Can you allow me to bring it on record
No. Why? When was it filed?
today?
Then? Why are you filing it today when the matter is on the list?
So, the instruction lately, Lord.
So lately you take time and bring it, connect it. Why should you trust it under our nose? You file it today morning.
Yes, Lordship, will better become
Item number 16.
16, Lord.
It is submitted there. What affidavit you are filing?
Affidavit reply against an additional
Affidavit in reply has been filed by the petitioner to the affidavit in opposition by the respondent. Let this matter be listed again the month of July on a date to be fixed by the registry.
paper short date.
July,
Prior
prior vacation. What is the subject matter? What is the subject matter?
prior-
Huh?
Say it's different, right?
Let it be in July. Yes.
Maybe, lordship, I beg to mention item number 30 and 31.
30 and 31.
There's some difficulty on our part.
30 and 31, somebody mentioned.
Well, 30 and 31. 32, 32.
Huh?
32, 30.
No, some matter 13.
30 and 31.
All right, 30, 31, yes.
There's some accommodation for today, some issues. File management.
Yes, Mr. Sorma.
My lord, there is some urgency actually regarding retail benefits on area salary. They have been deprived for last 9 years. These, my lord, whether matter can be taken on 8 June.
Let it be on 9th.
9.
Yes, 9th of June. has agreed to list by both council for the parties, list this matter again on 9/30/31. All right,
Yeah, Mr. Lordship. Sir, declaration item number 14 for withdrawal, Lordship.
14,
14 days.
learned counsel for the petitioner on instruction submits that the petitioner does not wish to press the petition any further. Accordingly, the writ petition stands dismissed from withdrawal.
Okay.
Please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 34, your lordship.
Yes.
Lordship may kindly adjourn the matter for the day, your lordship.
Who's for the petitioner?
Lordship, M.A. Islam.
Have you obtained instructions?
Lordship, yes. Lordship, also I have circulated the adjournment slip, your lordship.
Item 34 on the adjournment slips, the request made by the counsel for the respondent by way of adjournment slip duly signed by the counsel petitioner. Matter stands deferred to be listed after 2 weeks.
Wait, please, Lordship. Lordship, I beg to mention for listing of the repetition.
For what purpose?
Lordship, the matter relates to pensioner benefit. Pensioner has not received his salary from his retirement and already 2 years has elapsed, Lordship.
This is for admission.
Yes, Lordship.
By the 8th of June.
Please, lordship. Lordship, I beg to mention for admission, matter related to legalization of third.
The pleadings are complete. Affidavit filed
Yes, lordship.
by both parties. 11th.
Yes, lordship.
Sir, item number 17, kindly adjourn the matter for the day.
Item 17 on the request made by the counsel for the petitioner stands deferred to be listed after 1 month. Let it be after the vacation.
Your Honor, can it be on 9 June? I am appearing for the respondent number 4, item number 7.
Is there a stay order? Is there an interim order? No. Let it come in July. July. 17 July.
Must.
Yes.
May I please, your lordship, I beg to mention for listing of writ petition for motion
When was it filed?
yesterday.
Yesterday filed. All right. On Friday. 5th.
May I please, but I beg to mention listing on admission matter. Pleadings are accessible. Admission matter. Pleadings are accessible. Already we have filed our reply opposition is.
All right. 11th.
I'm applied.
This matter relates to compensation and ground. My lord, my case was not considered and deferred because of tendency of the retail bill, 3 years balance service. In the meantime, my lord, that has been disposed of, my lord. I have produced and judgment compensation for cheaper. In that line, that I may be disposed of. Directing the SLC to consider my.
Yes, Mr. Goswami.
Notice may go at this stage.
See the order. If it can be disposed of, we dispose it of. What else are you going to say?
Chip, I have to take some instruction also regarding the.
All right. Heard. Mr. N. Sharma, counsel for the
Dispose of, my
petitioner.
lord. The same in
Issue notice, return in 4 weeks. Mr. J.K. Goswami. Done it.
Additional senior government.
Additional senior government advocate appears and accepts notice on behalf of respondent 1, 3.
No, lordship, 1, 2, and 5, lordship.
1, 2, and 5. Mr. R. for respondent 3
Three
and
and
4. Therefore, since the notices, respondents are represented, notices are waived, extra copies be furnished within a period of 1 week. Yes.
the last occasion I was directed to apprise the honorable court. That may be reflected, my lord,
What?
regarding disposal of the retail bill on the first day, my lord.
The learned counsel for the petitioner has has informed the court that retail bill 287
Yes, ma'am.
stood disposed of, and similar matters have been considered by this bench, by this court, in terms of orders, in terms of the judgment and order passed by the appellate bench
dated 12/12/2025 in the appeal number 2.
Dated 12/12/25 in rate appeal number 287 of 2023. List after returnable. No, you don't. Pen. Yes.
Lordship, this contempt matter pertains to the direction of this honorable court for releasing the pension. Now the thing is that Lordship, in spite of submitting some representation, no action has been taken. In view of that, Lordship, this.
Notice issued here. No.
No, notice has not been
Council for parties issued notice returnable 4 weeks. Mr. S.P. Chaudhary. PS for the petition. Steps on the respondents by speed post within 1 week from today. List after returnable date.
issued.
Yes.
Mentioned in that way, Lordship. Lordship, last time I had taken time to, if necessary, we will file any rejoinder to the affidavit in opposition. But after going through the affidavit in opposition, we find that it is similar. So we have already given a reply. It can come for can be listed for hearing. And a date may be
It is submitted by the counsel for the petitioner that the affidavit has been filed and pleadings are complete. The matter be listed for hearing accordingly. It should all for reports. Listed in the month of August for hearing.
any date, Lordship.
No, it will come in part 2. You can make a mention.
In part 2.
It is in part 2, you are entitled to make a mention and upgrade it.
And okay. But otherwise, the matter is of 2019.
My lord, this is for the appointment of arbitrator.
Mhm.
In this case, my lord, one after another, they appointed their own officers as arbitrator. And 17 years have passed. And still the arbitration proceeding was pending before the arbitrator's mind. Then I approached my lord.
Arbitration. Yes.
And your lordship may kindly see the notice was issued on NHR 14.
It's fixed for others actually, my lord. It may come another day for admission hearing, my lord.
Why?
My lord, actually today I could not prepare, my lord. I have
No, this is where you want appointment of arbitrators.
Yes, my lord.
But my lord,
The
this
Honorable
is,
Supreme Court has dealt such type of case.
my lord, this is not regarding appointment of arbitration, my lord. I have raised the point, my lord, regarding, my lord, this section 11 petition does not lie, my lord, because it is substitution of arbitrator, my lord.
According to you, the arbitrator was appointed, but
Yes.
it could not be completed within 1 year.
My lord.
Is that the case?
17 years have passed, my lord.
As per the act, it has to be completed within 1 year.
Yes.
What
And
is the section?
Honorable Supreme Court has
Section.
section 11, my lord.
Section.
I have also filed the written synopsis, my lord.
And my lord, in our case, my lord,
Yes.
the bar, my lord, regarding 1.5 year, my lord, was not there at that point of time, my lord. And my lord, there, the argument raised by the petitioner is that, my lord, it is not regarding delay, my lord, that we cannot appoint fresh arbitrator. That is their point, my lord. Because, my lord, one arbitrator who is, my lord, in this case, my lord, he was transferred out, my lord. And we gave him a list, my lord, for replacement, my lord. And, my lord, he refused to give the name. Since, my lord, this new provision has come that railway cannot appoint his arbitrator. This is the case, my lord.
That he is entitled to.
My lord, I'll show from the, my lord, from the Act, my lord, and my lord, there are some judgment of this honorable Supreme Court, my lord, that my lord, it cannot be. It is my lord, substitution of the arbitrator, my lord, not a, but section 11(6) petition does apply, my lord. Yeah.
When was the arbitration arbitrator appointed?
My lord, at page number 115, my lord, the petitioner invoked the arbitration clause.
All right, when are you ready to address the court? Yes.
Well, next,
Not next week. What next week?
Thursday, my lord. Thursday.
All right, Thursday. We'll take it up on Thursday. List on Thursday. On the request made by the Council for the Railways.
11.
As also Mr. R. Hussain for the petitioner. Thursday. Hmm.
Content is noted the order of these honorable court, page 12. The order is dated 28/7/2023. The operative portion you'll also find at page 14. At paragraph B of the above. Currently at page 126, we file an additional effective. PCCF has forwarded a letter to the Commissioner and Secretary to forward this for releasing the pensionary benefit laws, but they are not.
Yeah, Mr. Gogoi, why have you?
My lord, there's a issue, my lord. He was not original our employee, my lords. Now there's a dispute regarding his entry in service book, my lords. And entire my lord, records have been seized by the police, my lords. We are not of the.
No, seized by the police, you can take copies of whatever you want.
They've taken,
That
my
can
lord.
be a ground.
Well, entire dispute is regarding his date of birth, which appears to be corrected by hand, my lords. And because, my lords, we have filed an affidavit.
You should have filed a review against this order. You have allowed this order to remain.
But that order, if lordship sees that order, without touching the core issue, my lords, it was left to us. Admitting, my lord, when we came to a record, my lord, we found out, my lords, that there are some discrepancies, my lord, because in our affidavit opposition, we found it gradation list, my lord, which was forwarded to him. He did not dispute his date of birth, my lord. That he accepted. In our affidavit opposition, my lords.
Was raised in the.
No, it was not raised. No, my lords, it was not raised. Lordship will see the first order, my lords.
Regarding the discrepancy
No,
on
my
the date of birth only. Thereafter, this order was passed. We have accepted the stand of the respondent that this date of birth we have accepted. They said that this can be considered.
What is his date of birth as per the petitioner?
31/3 date of retirement will be 31/3/2023. Date of birth.
And what about the department?
Department, my lord,
Now
will see.
they are saying that 1962 is the date of birth and 2022 will be the date of retirement. 01/04/2022. There's a 1 year delay, 1 year difference now, as per the department and the stand they have filed. But in the earlier writ petition,
My lord,
they had
earlier
accepted
petition,
this stand.
lordship, it was, we are constrained because nothing was forthcoming from the department. The lack of instructions, my lord. That is the reason, my lord, that the penultimate paragraph, the learned single just passing the order didn't touch the core issue, my lords.
Lordship, if your lordship looks into the order, our claim was there earlier, there was discrepancies in the date of birth of the petitioner in different records. So earlier, since there was a discrepancy, we approached the honorable court and there on the they have said that this 31/3/23 will be there because there was a communication to the accountant general and from 31/3 we have been
And my lord, how can they go beyond, the petitioner be allowed to go beyond record, because at the annexure, page 129 of the affidavit.
They
my
are
lord,
arguing this case in the contempt matter. Already these issues were raised in the first round of litigation.
my lord, even a review is under contemplation, my lord, because these facts, which didn't at that particular point of time didn't come to a light, our notice, my lords. Because at page 129, lordship will see he doesn't have any issue. He cannot reprobate or approbate at the same time, my lords, because that gradation list, when it was forwarded to him, it was clearly mentioned his date of birth. He didn't have any quarrel about that. And now his entire service book, my lords, has been seized by the investigating authorities, my lords.
So if it is seized, then you can have make copies out thereof. That can be a ground to deny him his pension.
My lord, since what has happened, my lord, he took a promotion and every benefit he took on the basis of the gradation list. After that, he comes and says, no, this is wrong, because now we have to recalculate everything. This is going to that issue, my lord. And we're contemplating a review, it's under preparation.
So that is not a ground. See, the court has disposed
My lord.
of course, without going into the merit.
Yes, my lord.
But it says that he will proceed on retirement with effect from 31/3/2023.
My lord.
You are now required to give him the benefits as per law. If in terms of the,
Well, he's getting provisional. He's getting provisional. But my lord,
why
we
don't
have-
you finalize it?
my lord, as soon as my lord, these investigation is has comes like
This investigation has got nothing to do with getting pension or not getting pension.
no, my lord, because the benefits which accrue to him, because he based on his own admission on a gradation list, my lord, some promotions are given to him.
See,
Now, if
there is no dispute that he was an employee
My lord.
under the department. There is no dispute that he will superannuate or has superannuated on a particular date. Dispute is with regard to the date on which he is to superannuate.
my lord, that will have a bearing effect, because if he retires a date prior to this, my lord,
Right.
some
So,
some benefits of
You have
promotion.
to now calculate and tell him that as per the department, this is the date you retire and this is the amount you'll get.
My lord.
You make a calculation and give him that.
My lord,
The investigations will follow its own course.
And my lord, already we are providing him the provisional pension. Man, this is we have to review, madam. That because these materials and
This
that
order was passed on 23, and in 26 you are asking time to file a review. That can be used.
On the every date, they come with one or the other ground.
No, my lord, this is
They
the
have
sole
filed
ground. my lord.
affidavit
No, what is
before
your,
affidavit.
what is the difficulty of the department? That is what
Lordship,
we want
see,
to
my lord,
understand.
this is
What is
not
the
my-
difficulty?
my lord, we are not denying anything. My lord, only the issue.
Then if you're not
my lord,
denying, you
page
release
21
it.
of the contempt petition itself, my lord.
Hmm?
Page 21 of the contempt petition.
21.
Page 21 at the bottom, my lord, will see
21.
21.
Bottom. 21 is
21,
December
my lords.
23.
This is an order, my lords. This is an
Hmm.
order. The PCCF has passed this order. Page 26, lordship will see paragraph 4. This is the whole hurdle we are facing. Well, paragraph 4, my lord, page 26. Entire his my lord's benefits has to be recalculated, my lord. We are doing that, my lords.
Does it take you 3 years to do that?
And it has
So,
to be there.
according to you, he retired from the post of what post? Forest Range Officer.
No, my lord, he service
He
head
was
cadre.
promoted on 30.
Forest utilization officer, my lord, which was his no, he was not entitled if we take this, my lords.
No. Read para 4. He was demoted to the rank of Forest Range Officer.
My lord,
So, therefore, he, according to the department, he retired as a Forest Range Officer.
my lord. Now, my lord, when you
And
see the
he
date,
was required to be promoted to which post?
This is retired on 31/3/2023, and he was promoted prior to that to assistant conservator of forest on 30/3/2023. Thereafter, after this order of this honorable court of 28/7/2023, this speaking order was passed on 5th of December 2023, wherein they have forfeited.
Have you challenged this
Yes,
order?
this is a, item number 8 is this challenge against this order on. When there is a stay order regarding
my
the
lord,
forfeiture
For
of
this contempt to,
for promotion
before
and
pressing this contempt, my lord, that dispute has to be settled.
the order of this order passed is at page 40, Lordship. This contempt petition only. Page 40.
Then why not pressing item number 8 instead of contempt?
Yes, my lord.
What is the stand of the department here?
My lord, we have filed an affidavit, my lord. We have brought on the record that gradation list, my lords, which was also forwarded to him. He didn't dispute, my lord, his gradations. I have lordship is taking up the affidavit. My lord.
Yes, item number 8.
Yes, ma'am. Item number 8, we have filed affidavit, ma'am.
We have seen that.
Yes, ma'am.
They have also filed a rejoinder.
Yes, ma'am.
Yes, tell us.
In item number, Lordship, in this case also, these all facts were brought before the.
What is your challenge here in
Lordship.
in item number 8?
That order, my lord, I had pointed out.
Page 66 is the order, Lordship.
60?
Page 66.
66.
Taking order.
Yes.
And the operative part, the Lordship will find it page 71. Order. Few of the above facts and circumstances. Order date. Number 1, the date of the Dalimdar is confirmed as 01/04/1962, first day of the month of April in year 1962, which is based on SSLC admit card issued by the Board of Secondary Assam Gauhati. Thereby, the effective date of superannuation Sri Dalimdar is finalized as 31/3/2022, and it may be deemed that Sri Dalimdar AFS has retired on 31/3/2022. All the documents such as pay allowances, etc., drawn by Sri Dalimdar AFS during the period of 01/04/2022 to 31/3/2022 shall be recovered from the retirement benefits under due process of law. Third point is that the matter of tampering of date of birth of Siranji in the service book is viewed with serious crime, and the same may be investigated by the Director of Vigilance and Anti-Corruption Assam. As brought out above, Sri Dalinda's deemed date of retirement is 31st of March 2022. The promotion granted to him by government order dated order so and so dated 30/3/2023 became infructuous and legally invalid and inadmissible, and Sri Dalindas is hereby therefore demoted to the rank of forest ranger.
Why the date was altered? What is the ground in the order?
My lord, we found out, my lords, that he was originally an employee of soil department.
No, we are asking the petitioner. We'll
My lords.
let him submit.
My lords.
Yes. What is the ground for the alteration by the department?
Alteration department, since there was a overwriting in the service book of the petitioner, and when they revised the matter and they found that admit card, the date of birth has been given as first day of month of April in the year 1962. So they have considered the date of birth as 1962. This exercise was done after the passing of the order in WPC number 3642 of 2023. It's the earlier round in which the content has been filed. And in that case, all the facts were brought before this honorable court. So Lordship all for the record of the dispose of case, Lordship. This petition we have filed.
The dispose of case did not answer anything on merit. That is evident from the order.
But Lordship, there was a discrepancy regarding.
And the court ultimately directed the respondents to release the
Yes.
pension as per law.
But the date of birth was they have accepted their stand, because our stand at the earlier round of litigation.
But if it is not reflected if it is contrary to the records will have to be relied upon.
But your Lordship,
Do you dispute the fact that this HSLC admit card is not supplied by you or is incorrect? Then
Not dispute.
Then if the date of birth is on 1st of April 1962, then your date of retirement would be 31st.
Looks into the admit card of the petitioner. There were different dates in the different records, Lord. And thereafter.
You know which date you were born and which admit card you have relied upon.
The only regarding.
Which admit card you rely upon?
Yes. The admit card will not find. 35. Page 35 is the admit card.
35.
Yes. Now here, Lordship, is it's not clear what is my date of birth. As mentioned here, is her age of on the first day of March 1980 was 17 years 11 months. So, Lordship, there may be miscalculation on the part of maybe the petitioner or the others, because this is the reason there is a discrepancy of 1 year, Lordship.
If this is not the correct date, then you have to take steps to correct it. Unless you get it corrected, the department will rely on this. And you did not bring it to the notice of the department that there is a discrepancy in the date of birth.
It is the reason we have filed this.
This is subsequently. During your service period, did you bring it to the notice?
We did not have the knowledge, right?
You did not have the knowledge. So therefore, now that you have the knowledge, you have to decide on what is the correct date of birth and what documents are you relying on.
Because the first document of school, high secondary school certificate is this.
This. So if this is the, if page 35 is the admit card which is accepted by you,
yes,
then what would be your date of birth?
As per this admit card would be 1962, Lords.
1962. So if it is 1962, then you retire on 31/3/22. Then?
If this admit card.
But this is your admit card.
Yes, Lord.
You don't dispute it. What else do you want?
But Lordship, in this case, earlier round of litigation also, the court this before this honorable court.
But have you seen the order which is ultimately passed? It is not a decision on merits, and it is made clear in that order. And your entitlement would be as per law. There is no finding that your date of birth is X or Y. It was left to the department. Department has decided. Now, unless you seek to challenge that this document is incorrect, then what else is there to be decided? You will be entitled to the payments as per the date of birth. Your benefits will accrue to you as on 31/3/2022.
I have worked for more for a year.
You have worked because everybody knows. Employees may not know on which date they will be confirmed, which date they will be promoted. But every employee knows on which date they are going to retire. We know which date we are going out of the system. There is no doubt. If there is a doubt, it is incumbent on you to raise this issue before the authority to say that this is incorrect. I'll retire on so and so date, but I should get 1 more year.
Because as per other documents, my date of birth was reflected as 1995 now, 1965. So my date of retirement would be on.
But you are accepting this document at 35.
Because this document at 35, but it's not directly mentioned that my date of birth is 1962. But as on
one can find out from this because it is said on first day of March 1980 you are so and so years. So one has to relate back and find out, and the date would be 1 for 1962. Unless you say that no, this is not my document, or there is an error in this document. Yes, Mr.
Well, in fact, he was the custodian of the service book, was also his original employer, Soil Conservation. At page 34, Lordship.
No, all right, we have understood everything. Now he has accepted the date. You have to release the payment.
Then if he accepted 62, well, we will process according.
How?
If he is
because according to your statement, all the The service book and everything is in the custody of the investigating authority.
Now we'll do the needful, my lord. Lordship passes the order, my lords. We'll come with that. We'll go and have a copy of them, whatever it is, because already we have sent those papers to my lord.
Yes, AG.
AG.
Yes, Lordship, after getting the pension proposal, Lordship, we finalized.
No, but before the pension proposal, what documents were sent to you?
Lordship,
Service
only
book and
one
everything.
CPF application, Lordship.
Huh?
CPF application.
GPF.
And that was also department wrote a letter to request us to again.
No. Right is there.
The contempt case, Lordship, I filed it.
Even in fact, my affidavit at page 115, para 18, the AG returns the book and what wants to authenticate that's a change of date of the
We dispose of these matters. You take all steps to release his pension with effect from 1st of April 2022.
Taking the accounts of the has been passed. 31st March 2020.
Yes.
This case, they have also passed an order regarding the recovery of my salary. Second is the
Bound to be.
if this matter.
If you have not worked, then we can direct them to adjust it with the pension.
On the part of the petitioner that the service book they have also not mentioned up before the date of retirement notes. And there are judgments Lordship, I will place give me some time because regarding the forfeiture of my promotion and my salary Lordship. This has to be Lordship considered. Because I have worked for the
You have worked knowing fully well that you're not supposed to
it
work.
was not to my knowledge.
How will it not be known to you? You are not a grade 4 employee. You're an officer working under the forest department. You don't know on which date you are going to retire.
That is the discrepancy.
There are people clamoring to go out on voluntary retirement, and you are enjoying working for the government for one more year. You're fascinated by the forest, is it?
Lordship, and my date of birth as per other documents were 1995 Lordship, 1965.
But you don't dispute the document at 35. Then don't dispute. This is a document given by another state authority.
This was already submitted before the initial when my appointment was done, and thereafter even my admit card was lost. I filed a FIR. Thereafter, I will obtain again the copy of this admit card from the Board of Secondary Education. This was not under my knowledge that my date of birth was there during that period.
You had
regarding the
how is it possible that you are not aware? When you are going for when you are given an appointment, you are required to produce the credentials.
At the first, this was at my service book. My date of birth was mentioned as 1965. There was a correction was made as 1963. There was corrections made, and thereafter this issue arise, and then we also came to know that it is 1962. Then there are 3-4 dates.
So who corrected it?
We don't know, Lordship.
What do you mean you don't know?
Here's the initial of
overwriting
director.
the service book, Lordship.
Have you filed an FIR? That it is without your knowledge, you are not aware somebody has interpolated the records?
This has been done only after my date of retirement of 31/3/2023, Lordship.
Yes.
My lord will see the initial, the service book, my lords, at page 38. There's an entry by the director of soil conservation. 9/6/23.
Yes. 1st of April 1962.
Yes, ma'am. And my lord, it was corrected, and he has not made this department also a party, my lord, if he's disputing this.
Yes.
Other day regarding this forfeiture of my promotion and this lots of salary. I have to execute. Address your notes. Yeah, because
Why
I
are
have
you not prepared today?
regarding because they have not come with the we have already the contempt case of this.
This is connected matter?
Yes.
Then? Thursday.
Thursday.
Okay. On the request made by the council for the petitioner, list again on, released on Thursday for further hearing. Mr. D. Ugoi for forest and Mr. R. K. Talukder for accountant. General. Part heard. Don't know. We'll dictate at 2 p.m. Yes. Yes, yes.
Order compliant.
Order compliant. You're reinstated. Have you seen the order?
Yes.
Okay.
Only the post was not mentioned.
District Project Officer, Solitpur District.
So it could be whether it's that or not.
How are you concerned? They have reinstated you as District Project Officer, Solitpur District. With effect from the date of taking over charge. Heard? Mr. A.J. Atia, Learned Counsel for Petitioner, Mr. S. Dr. hearing for the respondents, and Mr. So and so appears on behalf of Mr. D. Nath, appearing for respondent number.
Notice was not issued here. Does instruction not
As
a standing counsel.
Okay. On behalf of Mr. D. Nath, who was requested by the court to assist and apprise the court. Stop. The writ petitioner is aggrieved by the non-compliance of the directions contained in the order dated 10/9/2024, passed in WPC 3 of 2019, whereby the coordinate bench, while disposing of the matter, directed the respondents as under extract para 14, 15, 16, 17. Stop. Since this direction was not carried out, the petitioner has filed a contempt petition.
One of 2000.
The present contempt petition alleging willful disobedience of the directions contained in the order dated so and so, passed in WPC so and so. Para. The respondents, upon their instructions, has today placed before the court the order dated 27/7/2026, whereby the Chief Executive Officer of the Assam State Disaster Management Authority has, upon considering the matter, has reinstated the petitioner and posted him as the District Project Officer, Sonitpur, with effect from the date of taking over charge. Considering the above, considering the said order, this order is extracted below. Considering the above order, This court is of the view that since the directions contained in the order dated so and so have been complied with by the order extracted above, this court considers it, does not consider it necessary to proceed any further in the contempt petition. Accordingly, the contempt petition stands closed. Notices issued stand recalled, disposed.
Right.
Yes,
Please, Lordship, may kindly also for time being, my signature is late in other court.
time being,
Lordship,
right, time being.
helpful.
In terms of the instructions. Oh, this is resolved through mediation. Who's for the petitioner? Why are you withdrawing it? Client instruction, was it resolved? Was it settled in mediation? Settled. This matter was referred to mediation by order dated 24/2/2026. Stop. Before the mediator, the parties appeared. Stop. As per the mediation report, on the request made by the parties, some further time was sought for, and accordingly the matter was deferred. Stop. Para 2D, when the matter is called up, counsel for the petitioner submits, counsel for the parties submit that the matter has been settled out of court, and the writ petitioner does not wish to proceed any further in the writ petition. Accordingly, the writ petition stands dismissed as not pressed. Interim orders, if any, stand recalled. Pending ayes are also dismissed. Yes. Yes.
So on the last occasion of that, this judgment, where come.
Yeah, you tell us, you give us, refresh our memory.
Yes. Petitioner lordship he joined service on 19/5/1994 and retired from service on 30/9/2023 in the office of the executive engineer. After continuous service of 29 years, 4 months and 11 days. Lordship, when his pension proposal was sent to the AG office raised an objection that when he was brought under the regular establishment, that approval from the government was not taken. In fact, Lordship, the PW is a transferred subject as per amendment to the 6th schedule of the Constitution. And Lordship, that the Secretary of the Caribbean Autonomous Council has approved it, which is also in record.
Page number?
Page number
18.
Lordship. Approval of appointment of driver. I am directed to inform you that the authority of Caribbean Autonomous Council before is pleased to approve the name of Sri Mongol Singh Rongfar for regularization of his post from workshop driver to regular driver against existing vacancy. Sanction post in the office of the executive engineer, PWD R&B Mechanical Division. And Lordship, after that, Lordship, his service was regularized by order dated 24/2/2011 at page 21. Only objection was raised by the Accountant General Lordship that when I was brought under a regular establishment, that approval was not taken. So since approval is already there by the Caribbean Autonomous Council, so no further approval is required.
Now, in the memorandum of understanding, is PWD one of the subjects transferred?
Yes, Lordship.
Does not is not reflected.
PWD is there also.
Where is there? Memorandum of understanding.
And even in the affidavit filed by the department, council also, it has been, they have stated that admitted.
Is it?
Lots of, in annexure one.
Someone, we have a copy of the MOU.
Lots.
MOU does not reflect PWD is there.
Lots of, in the annexure one, lots of. The serial number 5 PWD is there.
Annexure 1 or?
One of MOU lots, which I have submitted on the.
Okay.
And in the affidavit also, they have admitted this fact
Right.
by the Karbi Anglong Autonomous. So my prayer is very limited since the approval is already there by the KSA and it is a transferred subject, so no further approval is required. And I have continuous service of lordship 29 years, 4 months and 11 days. And the other day also I have placed one judgment of the state of Gujarat versus Kalisbhai Dhanibhai Patel also.
No, that is on the question of service rendered, not regularized. Here the precise issue is whether a further approval is required from the state.
Not required.
On what basis are you saying it?
Also, even in the affidavit, lordship, if affidavit filed by the Karbi Anglong Autonomous Council, you can see.
Page number? Paragraph?
Paragraph 3 lordship. That in pursuant to the resolution adopted by the Assam Legislative Assembly on 12th April 1995.
Paragraph 3.
Paragraph 3. The Governor of Assam, in exercise of its power conferred by subparagraph 2 of paragraph 6 of the 6th schedule of the Constitution of India, and with the consent of the Karbi Anglong District Autonomous Council, was pleased to entrust and delegate the functions of 30 subjects, departments, including the Public Works Department, to which the executive powers of the state of Assam extends to the Karbi Anglong Autonomous Council, with effect from its publication in the official gazette by notification dated 29 June 1995.
Yes.
Vested with the council.
Now, why do you say further approval is necessary from the state?
AG.
Why AG? Why do you say further approval is necessary?
Lordship, in this regard, Lordship, Karbi Anglong Autonomous Council has filed one affidavit. Lordship may peruse Annexure 2, Lordship.
Annexure 2.
His service was regularized against one person, Nalini, after expiry of one person, Nalini Das, Lordship, which cannot, Lordship, Annexure 2, Lordship. Page 35, running page, Lordship. May I read, Lordship? This was written by the office, our office, Lordship, to the Executive Engineer, PWD, Lordship.
Yes.
With reference to letter so and so on the cited subject and state that the pension case was returned earlier by this October censure dated 19/9/23 and so dated 4/10/24 with the observation that the above incumbent joined in the service as workshop's grand driver on 19/5/94 and brought under regular status with effect from 24 to 2011 by the Executive Engineer PWD Rural R&B Mechanical Division Depot so and so. It is further requested to refer the government OM number so and so dated 28/12/99 as regard regularization of workshops and MR labor, where it is clearly mentioned that this is important, Lordship, that the post once vacated by incumbents due to their promotion, gradation, resignation, retirement, death shall automatically cease to exist. As such, question of filling up the post once vacated by the original incumbent does not arise. Here in this case, Lordship, after expiry of one person, Nalini Das, his post was regularized against that post, Lordship, which cannot as per this office memorandum. That was the issue, Lordship.
This is this letter, this order which is enclosed, I referred to.
Yes.
This is the perhaps a regularization of the person who was there in the post earlier.
Yes.
Nalini Das.
Yes, Lordship. Against that post, his
So
service.
once the person expires, if it is a personal post,
yes,
goes back to the government. means the state.
Those things were never objected also till my retirement.
Never objected, but his objection is again from the accountant general. Accountant general will have reason to look into your case only upon the proposal being sent.
Okay, as per the 2000 office memorandum, also only 20 years of continuous services required. One more
No,
notification.
no, no. Those are later. 20 years of service in a post where you are regularly appointed. According to you, you are regularly appointed by the council in a post which was made vacant by the demise of the earlier incumbent. The earlier incumbent was perhaps regularized in a supernumerary post, where the order is that once the post falls vacant, no further appointment in that post. It goes back to gets dissolved.
My service was regularized in the sanction vacant after expiry of.
Now, where is the proposal for creating a sanction post? There has to be a proposal.
There are two parts, my lord. One part is, my lord, regularization. Second part is the regular appointment. The workers employees who were appointed prior to 1493, my lord, they are required to be regularized. But in this case, my lord, the period, workers period, my lord, after 1493. So if you lordship look into the annexure 4 page 37, he was appointed against a regular vacant post in the year 2011, my lord. So, but his claim is from 1994 to 2011. That period, my lord, workers period, there is no policy of the government for regularization of the workers employee. So that period, government has not regularized, my lord. But from the date of appointment in the against the regular sanction vacant post, my lord. So we are writing to the chief engineer, annexure 4 page 37. We have specifically mentioned that he was appointed against a regular sanction vacant post in the year 2011 only. But he is claiming from 94 to 2011, my lord, that workers period, my lord. That workers period, my lord, there is no policy of the government for regularization. Now the Upenda's case is, my lord, set aside by the Supreme Court, my lord. In that judgment also, my lord, that prior to 1493, who were appointed, the workers employees, they are required to be regularized by the government with a period of 1 year, my lord. And they are entitled to all the benefits. But in this particular case, his appointment is after 1493, my lord, workers, as per his own document, annexure 1, my lord. 1. So he is not entitled for regulation till the government framed a policy for regulation of the workers employee who were appointed after 1493. And if he is not claiming that particular period, then his pension paper can be processed on the basis of his regular appointment made in the year 2011, on 3 to 2011. That is annexure 4. It is clear from the annexure 4, my lord.
So even in terms of paragraph 53 of Uma Devi Lordship, I am entitled to Lordship. It says Lordship to regularize as a one-time measure the services of such irregularly appointed.
No. You
10
see,
years.
either you say that the authorities have regularized you. No further process is necessary. Or your case will now have to be considered for regularization. And you are entitled
For the workers period.
for the work charge period.
So to that effect also one judgment I have come. Today onwards.
You are claiming from 94.
From 1994 to 2011, regulation of workers period for that period.
Huh?
Regularization, he sought the regulation from 1994 to 2011.
In this case, Lordship.
Wait. First tell us, you were in service on which date?
Lordship, I joined service on Lordship 1994.
94 you were
1994.
you joined as what?
As Lordship
Workers, assistant.
first appointment. Lordship.
Under which department?
Under the same department, executive engineer, PWD, R&D, mechanical division.
Posted at,
Annexure 1 also.
posted at,
Posted at also. My first appointment order also I have Annexure 1 also. Posted at default also. Before the assistant executive engineer, PWD R&B, mechanical subdivision default.
default. Then you were brought into regular cadre with effect from?
From 3 to 2011.
So from 94 to 2011, you are seeking regularization. You are brought into regular cadre with
It should
effect.
be dim regularization because Lordship till my retirement, they have not raised any objection. I was under a legitimate expectation of say I would be receiving the pension and other things. Only after retirement.
You
Lordship,
retired on which date?
on Lordship 39 2023.
30.
Yes, Lordship. 30 September 2023. Also, the principle of promissory estoppel will also apply here because I was under a dim regularization also. Not a single break also. I have been continuously working since 1995, 94. And it has been admitted in the affidavit also.
But you have accepted this 3 to 11, isn't it?
Yes, sir.
There was no challenge that your regularization ought to be considered to be with effect from 94. Was there any challenge earlier?
No.
Then?
But the objection has been by the Lordship SG office only with regard to approval. That regularization period has not been questioned also.
No, regularization, you can be regularized only when you are appointed against a regular vacancy. Now the question is that the objection raised by the Accountant General also cannot be said to be unfounded because the person who was regularly appointed, who expired, that post is a personal post. It goes with the person retiring or expiring in the while working.
As per their office manual.
As per the order itself, order of regularization. Now, therefore, the question would be that what would be necessary for the Karbi Anglong to create a supernumerary post if required for.
My lord, we have no power for my lord regularization or for my lord creation of the post.
From what? From where are you saying that?
My lord, if you lordship the notification, my lord, issued by the government, my lord, we have the power of appointment in grade 3 and grade 4 posts, and the principal secretary has the power of approval.
Where is that?
My lord, we have not brought it to the record, my lord. We have
This is what post?
on the grade 3 and grade 4 post.
This driver is a grade 4.
Grade 4.
If you Lordship look into my lord, annexure 4 is 37. That later itself clear that he was appointed against the my lord, not the supernumerary post, my lord. He was appointed against the regular sanction vacant post of driver, my lord, truck driver.
No, but the AG has raised the
My
objection.
lord, so it is required to be look into my lord.
No. He is appointed in the regular sanction vacant post due to retirement of Nalini Das.
That's my lord.
So Nalini Das was a person who was appointed in a supernumerary post.
There is nothing on record, my lord, that he was
Their
appointed.
objection is there.
Here objection at that, my lord. So to clear that objection, my lord, we wrote to the my lord chief engineer, my lord. So my lord chief engineer, we wrote to the chief engineer clarifying that point, my lord.
Then what was the reply?
There is no reply on that, my lord. At today, the my lord, PWC council
No,
is not
but
present.
you have access. You can have access to the document which is relied upon by the accountant general.
Right.
If you look into it, perhaps
My lord,
do you have a copy of that order?
Yes, my lord.
In which Nalini Das was appointed?
My lord. But no, that is not there, my lord.
So you get a copy of that order. If you have a copy of that order,
Nolin does, my lord.
uh,
My lord. Then we will clarify it.
what is the judgment you want to show? Prem Singh.
Print.
Uh,
Last paragraph of
After that, lot of the other judgments have come. Again, Prem Singh was clarified, I think. What is the last paragraph? Para 36.
Yes, yes.
Huh?
Last.
Para 36.
Para.
This was clarified subsequently, which was held to be not proper by another subsequent judgment.
This order was not set.
Huh?
That was also I have gone to judgment also.
Oh.
But this has not been touched also. That was not relied upon.
This was
In
clarified.
the subsequent judgment, it has been said that this judgment which was placed is misplaced.
Misplaced. That was again not accepted by still subsequent bench.
Here also it is very clear. The boxes period should be counted.
And what is the judgment in Upen Das?
Upenda's judgment has been also set aside. In second, the water set will also have the judgment.
Give us the judgment.
Also, even post regularization also I was receiving salary. So our honorable court has held also. An employee also who has rendered continuous service is entitled to pension if regularization is established, respective of procedural lapses, and also post retirement losses if I have received the salary that I have placed also before Viva Borgopatiki and Professor Patel also. The earlier on the earlier last occasion also I have placed 3 judgment.
Give us the citation.
Lots of. One is Rashmi Rakha Soikia, that is WPC 1482 2011.
WPC
1482 2011.
1482 2011.
2021, sorry.
Date of the order?
Date of the order also 7/1/2026.
7/1/26. What is the name of the party?
Rashmi Rakha Soikia versus State of Assam.
Yes, then
Then also the WPC 1281 of 2024.
disposed of on
13 to 2026.
party
Riva Borkataki versus State of Assam.
Nibha,
Riva Borkataki.
RIVA,
RIV.
Borkotoki,
Borkataki.
and
And also Bogeshwar Patar versus State of Assam. Shared on 11/4/2006.
date, the name, the citation, WPC
WPC 7938 of 2005.
79.
7938 of 2005.
2005.
Paragraph 13.
What is the name of the party?
Bogeshwar Patar versus State of Assam.
Date of the order?
Date of the order was 11/4/2006. And the Gujarat judgment was I have also. Gujarat Supreme Court judgment.
Hanjilal.
Yes. State of Gujarat and others versus Talis Bhai.
What is the
Hanji Bhai
citation?
Citation lordship 2022 lordship is Supreme Court judgment is not here. Lordship I have.
Is that,
2022 legal SC 195.
do you have the SCC?
SC citation lordship I don't have.
2022
legal SC 195. Special repetition is 1109 of 2020.
What is the party name?
Lordship, State of Gujarat and others versus Talis Bhai, Tanji Bhai Patel. State of Gujarat and others versus Tanji Bhai Patel. In this judgment also giving in ad hoc capacity lordship, the person is entitled to pension.
Have you gone through the judgment? This Upendas?
My lord. My lord, I have gone through it. Before that, my lord, what we will look into, my lord, regarding the appointment regarding approval of the, my lord, finance department in respect of the, my lord, driver is required. My lord. There are two circulars and, my lord, that the office memorandum also, and placing it for your consideration.
Yes. So, but is it not clear from your this office memorandum, 20th of March? Of requiring sanction?
My lord, sanction is, my lord, it is also clear, my lord, that earlier that we have to require the approval of the finance department to fill up the post, my lord. Subsequently, in 2015, my lord, that was relaxed except, my lord, teachers and driver, my lord. For appointment of driver, approval of the finance department is required. These are two circulars, my lord. And regarding the, my lord, that notification is relied by the, my lord, accountant general, that is also there.
Which office memorandum?
In
30th of March.
My lord.
1299.
Huh?
28/12/99. Which I am relying.
28/12/1999.
That is why I am of government. Second paragraph. One is notice that personal post regarding.
Where is the approval? Mr. Sutia? You say some approval is required for?
My lord, para 7, my lord, 2012 notification. Yeah, right. That's one thing to go down.
May I place one office memorandum, 6/9/2003. One office memorandum.
Don't, you have filed pleading, why you giving loose papers, whatever you want to bring it on record by way of additional pleadings. I'm talking, the respondents also, you are giving us
My lord,
as if something, this is something it has come from heavens,
my lord.
not entitled for regular people.
My lord.
Whatever you want to rely on, bring it on
My lord,
additional
my lord,
pleadings.
my lord. Regarding, my lord, that is also required to be clarified regarding Nolini Das post, my lord, whether it's a sanctioned post or, my lord, supernumerary post, my lord. That instruction I don't have, my lord.
No. Nolini Das is not a newly created post.
My lord,
Otherwise, the AG would not have raised an objection.
my lord.
AG's objection is that it was held by one person, supernumerary post, he expired. So the post goes. How do you?
My lord, you cannot fill up one.
You cannot. How do you regularize the person?
My lord. That 99, my lord, that was notification we have annexed it in our affidavit, my lord. Handed over, my lord. We have annexed it as annexure 1, page 30.
Which one?
The 1999 notification that has been relied, my lord, AG, my lord, we have annexed in our affidavit, my lord.
Yes.
My lord. The post once vacated by the incumbent due to their promotion, graduation, resignation, retirement date, etc., shall automatically cease to exist. As such, the question of filling up this post once vacated by the original incumbent does not arise, my lord. That is the notification. But in the, my lord, our later annexure 4, it has been mentioned that it is against the regular sanctioned vacant post, not the supernumerary post. In annexure 4, we have mentioned it. We wrote to the chief engineer stating that it is the regular sanctioned vacant post. If it is a supernumerary post, it cannot be regular sanctioned vacant post. So we have clarified it to the government. So the government is required to take steps on that point.
Government is required to take what steps?
But if the petitioner sought the regulation that particular period.
No, no, you regularize him.
My lord, we have no power for regulation.
You have brought him under the regular establishment.
Regular establishment brought under regular establishment against the regular sanction post means it is a regular appointment, my lord.
That's
Not
right.
the regulation.
Right.
But he is seeking that from 1994 to 2011.
But AG is objecting to this also.
My lord,
Then?
objecting this. That has been, we have already clarified to the chief engineer, my lord. But it is also required to be clarified to the AG also that he was brought against the regular sanction vacant post in 2011. That his pension paper can be, my lord, if it is.
2011 vacant post is a post arising out of Nolini Das.
My lord.
Now, how was Nolini Das holding this
Post, my lord.
post?
That is required to be clarified.
Right.
Basic point now only on that point, my lord. Only if he is entitled for pension from 2011 only.
And what is the ratio of this judgment of
Sukendra Bhattacharjee,
Bhattacharjee?
That in that judgment, my lord, those who were appointed appointed as a workers or master role in the year before 1493, they are entitled to all the benefits, my lord. But in the Upendra's case, my lord, in our division bench said that those who are regularized, that has already regularized, as there is no policy, there cannot be any regularization. But in the Supreme Court said that within the 1 year, the state government is required to take steps for regularization of the persons who were appointed prior to 1493, as 30,000 employee has already been regularized by office promotion, by policy of the government. Yes, sir.
It's only in respect of master role.
Yes. So whatever direction has been issued there, it is only in respect of master of law. So here the petitioner is a workers employee, that is one lordship. And secondly, lordship, in that case, lordship, the honorable court was considering the master role and workers employees who were appointed prior to 1/4/1993 only. Like here his appointment is 19/5/1994. That is another issue, lordship. And in specific of this case, lordship, if lordship comes to page 22. Page 22.
Of the judgment.
No, of the writ petition.
Yes.
If lordship comes to the last 3 line, is brought under regular establishment in against the existing sanction vacant post. So there was no post was created, the post was existing. So he was brought under a regular establishment, lordship. So subsequently, this regularization was disapproved by the authority, lordship. They themselves are saying that he was not the authority. The executive engineer was not the authority. Even if this regularization order is held to be good, lordship, it has to be considered as a fresh appointment, lordship. Not beyond that. It has to be considered as a fresh appointment.
Why?
Because his appointment was against a sanction vacant. So far as the regularization is concerned, lordship, for regularization of master, be it master.
Where is the original order of appointment in your?
Next one. Page 15.
What, sir? Page 15.
This also talks about a post.
Now this is work, sir. In persons of instruction so and so, the following persons are hereby appointed in a post mentioned below against machine vehicle number so and so in workshops establishment.
Workshop establishment.
Workshops is not a regular establishment. So I think in this matter, lots of detailed affidavit from PW as well as from finance. as well as
Finance
from-
is a party.
Yes, finance. is a party.
Can you bring your affidavit?
Lots.
So,
Only the treasury officer, finance has not even met party.
so what has happened is that number one, you are objecting to the fact that he is employed in a regular establishment, regular vacancy,
Sanction vacant.
sanctioned vacant.
So it is not a ex-cadre or personal,
It was a work charge.
that which was not created for it.
Subsequently, there was some vacancy, he was brought into the regular.
Yes.
So therefore, the service rendered in the work charge period cannot be utilized for, would be a separate, would have to be truncated from the appointment made subsequently to the sanctioned vacant post.
As it was against a sanctioned vacant post, at best it can be regarded
Fresh.
as a fresh appointment. But
And which
that-
again
but-
the,
but
which,
that is also even subject to the finding lordship. Ultimately, lordship will find whether the concerned executive engineer had the authority to appoint him against a regular sanction post or not. So that is what AG has objected.
and how are master role workers appointed? Against what?
Against no post, wage basis lordship, master basis. Now the concept is lordship, workshops is also an establishment lordship, not a regular establishment lordship. For that also lordship, under Assam financial rules lordship, there is a specific provisions. Even the workshops posts are required to be created lordship, or of government approval should have been there. But in these cases lordship will see they were engaged, not even against sanction, I mean post approved by the government.
First, you give them the responsibility under 6th schedule. You transfer the posts.
Yes.
Then you say that no sanction.
These are not post law. So far as workshops is concerned, these are not post lordship. Lordship may at best call it a position. These are not, I mean,
No, these are not posts as per Government of Assam.
yes.
But as far as the council
Okay.
is concerned,
Lordship,
they may define or redefine in the
my
different
senior
issue.
colleague just now has produced one OM of 2015 lordship.
Hmm.
Therein also lordship, secretarial authorities has been given the authority to create and approve for appointment lordship, except the post in the education department and the post of driver.
This is opposed to the constitutional framework because they are 6th schedule. They should be given the full powers and full autonomy instead of curtailing some of the, but they are not objecting. Who are we to apprise them?
Lordship may deliberate on that issue, but that is not relevant, I think, so far as this petition is concerned.
No. It's relevant because it's a 6th schedule.
Yes.
What is the purpose of 6th schedule? If for every sanction, they'll have to refer to the Government of Assam for.
Even in that
approval.
situation, Lordship, even if it is held that government's approval is not required, question will remain, Lordship, whether the executive engineer is the competent authority or not.
But that is for the council to say.
Yes.
If the council says it is okay.
So at this stage, Lordship, my prayer will be, Lordship, let the respondents find their executive.
We have heard this matter. Where were you on the last occasions? Nobody represented finance.
Finance is not an independent party, Lordship. Today I'm appearing for PWD, Lordship.
PWD.
And treasury officer is there.
PWD has not filed the affidavit. You have filed your. Have you filed your affidavit?
Not. Lordship, I will not take much time. Lordship, can be 2 weeks time, Lordship.
Mr. Das, It is not what you have projected the matter to be, appears to be. There are some issues which will have to be ironed out.
I'm a grade 4 employee, Lordship.
Your
I
grade
have
4
done that.
employee is all right, but you are a grade 4 employee, your entry into the service, the services you have rendered, everything will have to be now looked into. And you are relying on the Sukhendu Bhattacharjee. Which paragraphs?
Also, even Sukenda Bhattacharjee, also the cutoff that is giving
That has no relevance for you.
But in Uma Devi's case, paragraph 53 also I am covered. Because in paragraph 53 of the Uma Devi also to regularize as a one-time measure the services of staff irregularly appointed who have worked for 10 years or more, as on 10/4/2006. Also by Uma Devi's paragraph 53 I am covered. Uma Devi has been also discussed in this Sukenda Bhattacharjee.
All right. You complete the pleadings by bringing whatever notification, office memorandums you are relying on, please bring it on record. Third, counsel for the parties, the claim of the petitioner is for release of his pensionary benefits for the services rendered as a driver under the Department of PWD in the under the Karbi Anglong Autonomous under the Karbi Anglong Autonomous Council. So, petitioner was initially appointed as driver by order dated 18/6/1994 against a machine/vehicle number in the work charge establishment. So he continued to do so until he was regularized.
Brought under
Until the department approved the name of the petitioner for regularization of his post from work charge driver to regular driver against the existing vacancy sanctioned in the post of the Office of the Executive Engineer, PWD R&B, Mechanical Division, Diffu, by order dated 3/2/2011. Stop. The petitioner subsequently superannuated on 30/09/2023. Stop. Upon his papers being sent for sanction of pension by the authorities, the Treasury Officer, Diffu. Is it the Treasury Officer? No, Accountant General. Who raised the objection? Accountant General. The Accountant General, by communication dated 4th of October 2024, issued to the Executive Engineer, PWD R&B Mechanical Division, Diffu, raised a query that in terms of the office memorandum number FEC within bracket 1/99 dated 28/11 to 1999, which had enclosed the names of incumbents therein. It was stated in the said notification issued by the government that the persons named in the list were regularized. However, the post which will fall vacant after the expiry or superannuation of the persons whose names are included in the said office memorandum dated 28/12/1999 shall not be treated to be clear vacancies for filling up the post by subsequent recruitment, as these posts, as the persons were regularized only on supernumerary posts. Stop. Under such circumstances, since the name of the petitioner was not available in the list, a query was raised by the Accountant General's office. Stop. The executive engineer submitted its reply by enforcing all the relevant documents and reiterating that the petitioner was regularized in a vacant post of driver sanctioned by the Office of the Chief Engineer Roads dated 2011-1980. The Karbi Anglong Autonomous Council has raised the objection that the petitioner's claim cannot be entertained for grant of pension with effect from his date of initial entry in the year 1994, as it is with effect from 3/2/2011 that the petitioner's services were brought into regular cadre, and his period of services rendered prior to that cannot be counted for regularization. Stop. It is further submitted that in terms of the MOU executed by and between the state of Assam and the Karbi Anglong Autonomous Council, as also the subsequent office memorandums, the council, Autonomous Council, is not empowered to create posts. For creation, the sanction of the government of Assam will be necessary in posts, including the posts in grade 3 and grade 4. Stop. In the transferred subjects, including that of PWD. Stop. Where Mr. Nayak, additional AG, appearing for the PWD on the other end, submits that the petitioner was initially appointed as a work charge driver. Stop. Therefore, there is no question of counting his services for pensionary benefits till the time he is brought into regular cadre. Stop. Referring to the order dated 24/2/2011. Sorry. Three to 2011. It is submitted that for creation of post, sanction of the government, including the finance department, is necessary. Therefore, it is not available for the Office of the Chief Engineer, PWD, create a regular post to accommodate the writ petitioner. Stop. That is your submission? That they are not authorized to create without the sanction.
No, I mean, the post is there already. No requirement of creation. Here, he was brought under regular establishment against the existing sanctioned vacant post. So it was held by somebody else. He retired. In that post, he was appointed. So what I'm submitting, Lordship, this executive engineer did not have the authority to engage somebody against the regular. So his initial appointment letter, I mean, this order.
The his engagement under work charge.
Initially, work charge is okay, Lordship. That I'm not questioning. But subsequently at page 22, Lordship, that bringing him under regular establishment. That is 24/2/2011 order.
No, this is in pursuance to page number 18. This is in pursuance to page number 18. This is only a follow-up order.
This was also by the Karbi Anglong authorities.
That is what we are saying. Your objection is that they have no authority to sanction a post without the approval.
Yes.
Well, he said that the Karbi Anglong Autonomous Council also does not have the authority to create or sanction a post for regular vacancy without following the proper procedure by for approval of the government and the finance department. Stop. The net council appearing for the PWD, however, submits that he has not been able to file the affidavit. He wants to bring on record the relevant materials to substantiate his arguments by filing an affidavit, if permitted. So, para counsel for the petitioner, meanwhile, refers to the following judgments in connection with his, in support of his case, the Lika asylum. The considering the submissions raised, the question before the court is whether the services rendered by the petitioner under the work charge establishment by can be considered for counting towards his pensionary benefit. And number one, whether the order passed by the Karbi Anglong Authority, Karbi Anglong Autonomous Council, bringing their petitioner services from work charge establishment into the by regularizing his post to a regular driver against an existing vacancy of sanctioned post in the office of executive engineer PWD R&B mechanical division requires any sanction of the government. Number two, whether the objection raised by the Accountant General that the post in which the petitioner is sought to be regularized was earlier held by one Nolin Das, who was regularized by the OM dated FEC number 1, FEC 199 dated 28/12/1999. No, sorry. What is that OM?
28/12/19.
No. Where is the name of Nalin Das was there?
That was not.
You have raised the objection. Where have you raised the objection?
It's 35%. And it's a two file, executing opposition filed by the Karbi.
35. Objection raised by Accountant General YD Communication dated 6th of February that whether the petitioner can be brought under the regularization can be regularized, or his services can be brought under the regular cadre without his name being reflected in the government OM number FEC within bracket 1452/99 dated 28/12/1999, where it was clearly mentioned that posts once vacated by the incumbents due to their promotion/gradation/resignation/retirement/death shall automatically cease to exist. And therefore, the posts vacated by Nalin Das would have been filled up by the writ petitioner. Stop. Accordingly, let this matter be listed again after.
Is this matter after vacation? In the meantime, I have my affidavit. I'm staying for 3 weeks long.
Mr. Das,
Can you give the money? The gratuity amount has not been released. So a person is only, as per section 4 of the gratuity act, only 5 years of service is required.
we'll have it on 16th. You please endeavor to file your affidavit if you want by 16th of June. 16th of June. Yes,
Obliged.
list accordingly.
IV item 35.
Lordship has already kept it as part. It is already part.
All right, parted.
Obliged.
Yes, Mr. Nath.
But I have received an instructions in the morning today, Lord. But in fact, it is the entire Lord, file has been placed before the competent authority. Lord, it is at the final stage, but they will do it. Lord. And they have prayed for some time. Lordship may grant me. They have prayed for 2 weeks time. But along with the records and everything, Lord, it has been placed for final approval, and it will be done.
Mr. D.P. Bora for the petitioner, Mr. D. Nath for the respondent. Mr. Nath has placed before the court copy of the instructions received that the steps are being taken to comply with the directions of the order dated 15/12/2023 passed by this court in WBC 7193 of 2023. And for this purpose, a further period of 2 weeks is prayed for. Accordingly, this court, considering the prayer made, directs the matter to be listed again on 19th June, by which date it is expected that the directions required to be complied with the department may be complied with.
Highly obliged.
Obliged.
Item 12.
But all the petitioners before this honorable court, my lord, earlier initially the year 2010, 2000 they were selected, my lord, and but some of them already appointed for 2005. Police verification also not done, my lord, but appointment letters not given, my lord. Subsequently, my lord, they are processing, my lord. In the meantime, new press advertisement also published, my lord. So, my lord, they are just now grievance is there, my lord. They have applied for. They are all qualified, matriculate. All it is covered by the recent judgment. Also, they can be able to get their job, my lord, as they have applied for also, my lord.
What is the recent judgment?
No, my lord. Recent judgment, my lord. That is, I have annexed here. Some of them, my lord, already got their job, but they were, my lord, selected and appointed. Here, these petitioners, my lord, did not. My lord, those selected, not appointed, but they are, my lord, submitting representation one after another, my lord.
For?
For their, my lord, adjustment in the post of the
When were they selected?
selected in the year 2000, my lord.
How can the select list carry on for so many years?
But recently they have, my lord, already adjusted, my lord, some of them, my lord. Just
How can
kindly
that be
peruse
done?
104, page 104. Just I am praying for, my lord, only the weightage, my lord. Because kindly peruse your lordship.
Is it permissible under the?
সন্মান জনাও যে মাটিয়া ৰাজচক্ৰ বিভিন্ন গাঁৱৰ স্থানীয় বাসিন্দা শিক্ষিত নিবনুৱা লোক হয় 2000 যোৱা ইংৰাজীত 2000 ছাব্বিশ জুন তারিখে গোৱালপাৰা জিলাৰ ৰাজহ
This is your representation.
Yes, my lord. But
It
that
is-
has been, they have considered, my lord. They have wrote to the, my lord, the joint secretary wrote to the deputy commissioner, my lord.
No, but these are in respect of a selection conducted in the year 2000.
2000, my lord.
How can the select list continue for 6 years?
But recently, my lord, those are the selected candidates are adjusted, my lord, after the judgment, my lord.
That is not proper.
So my lord, they have also
After- which
already applied,
which
my lord.
judgment you are referring to?
Lordship?
Which judgment you are referring to?
No, no. These judgment, my lord, our colleagues, my lord, already appointed, my lord. And
Which judgment? Which
yes, my
judgment?
lord. I have annex here, my lord, that is placed.
128.
Yes, my lord. One 129 really.
Were you petitioners before the court?
Lordship?
No, Lordship.
You are not petitioners.
No, no. They have
Okay.
already appointed, my lord. Those who filed this case, my lord.
These petitioners are not belongs to that case.
Only 66%.
Among Lordship, that 66, they are not there.
Well, out of 520, they were there, my lord. They filed this case. 520 were selected, my lord. But these petitioners also selected. Police verification also done, but appointment letter not given.
You have, my lord, in this case, you the press advertisement and given lordship, the NXR 18 of the PS 114.
Did they participate?
Yes,
They
yes.
participate.
Or party. Calling
All
letter.
letter has been given, my lord, that, the result has not been, my lord.
Declared. Then what is your prayer now?
Now, my prayer is only to obtain, my lord, some weightage, my lord, because
How
as
can lordship, he will not be.
or
appointed by the, my lord,
representation may be
government.
considered,
No,
my lord.
they are
Our
taking the, my lord, to witness.
Weightage of what?
earlier, my lord, selection and my lord, earlier selection, because we are waiting. Kindly, Peruzio, let's say, best people one, my
No,
lord.
no, weightage in what aspect?
In respect of, my lord, earlier.
Age benefit.
Yes, my lord. In the next, my lord, because in this new process also we have applied for, my lord. As we
What
have
weightage are you asking for? Weightage in which category?
Yes, my lord. For our recruitment, my lord, as we are the all personnel already selected, my lord. Police verification also done. That only that much, my lord.
In the advertisement, was anything mentioned?
No, my lord, not mentioned.
Then
That is, my lord, 104, kindly peruse your lordship. We have submitted representation and the, my lord, joint secretary also wrote to the deputy commissioner, my lord, people one. Annexus 17.
saying what?
Saying, my lord, with representation dated so and so, Mukul Kolita petitioner in connection with the appointment of Gaur Pradhan in Golpara district. With reference to the subject cited above, I am directed to forward herewith a copy of the representation dated so and so, along with the enclosures submitted by Mukul Sundar Kolita and others, and to inform you that the petitioner claimed themselves as honorary Gaur Pradhan in Golpara district and
You are
the
asking for preference.
preference, my lord.
How can preference be given?
And requested to give preference to themselves.
How can the direction be issued to give a preference?
Or we submit representation also, my lord. That may be considered, my lord.
You have already submitted representation.
Already submitted and also forwarded, and the commissioner also wrote this, my lord, and the joint secretary also, my lord.
It heard Mr. H. Das, learned counsel for the petitioner.
Kindly see one of them where their pair person is setting aside the advertisement.
No. We have applied for. We have already filed additional affidavit
Who were
also earlier, my lord.
selected for being appointed as honorary Gambura
Yes, my lord.
pursuant to a recruitment process initiated by the state. The petitioners claim that their cases, they were selected candidates, however, the appointments were not granted. Although some of the other selected persons were permitted to be were appointed as honorary Gamburas, and their appointments were then terminated, but again subsequently restored by the government pursuant to orders passed by the court in a review jurisdiction. Petitioners claim that they are they were similarly situated to those persons, and they are also
Police verification.
they had also participated in the subsequent advertisement dated 2004-2023, and police verification, etc., have already been undertaken.
Not 20.
No.
Earlier.
23, no police.
No, in the new advertisement, you did not participate.
Yes. No.
They are participating. The result has not been declared.
What are you saying? Did you participate or not?
Participated, man.
Then that is what we are
Result
saying.
not declared. Result not.
What is your objection, Mr. Goswami?
Regarding?
You raised some objection, this 2004-23. What is this?
No, that lordship, they stated that they are working as a Gaon Pradhan lordship. The objection.
You're not saying that. Don't interrupt while we are dictating the order. If you have to say something, wait for the orders to be dictated, then you point out. Why do you interrupt? They had also participated in the advertisement dated 2004-2023, for which police verification, etc., has been undertaken. Stop. It is the apprehension expressed by the petitioners that in spite of they having been selected in the earlier round of earlier process for recruitment, in the subsequent advertisement, their cases may not be considered, as there are several younger persons who are participating in the present selection process. Stop. The petitioners, therefore, had ventilated their grievances before the authorities by filing a representation. Where is the representation?
Representation 104 page.
Dated
21/10/22.
21/10/2022. Before the secretary Department of Revenue requesting for consideration of their cases
For weightage.
by giving them preference, considering the fact that they had earlier participated in the recruitment process, which stood abandoned, and a subsequent recruitment process has now been initiated. Earlier process was abandoned. Stop.
Alia,
This representation has also been forwarded to the commissioner,
yes, my lord, the
deputy commissioner.
deputy commissioner, yes, my lord. Joint secretary wrote to the, my lord, deputy commissioner and also my lord, joint secretary also.
However, no such confirmation or no such order have been passed by the authorities concerned, considering the prayers made by the petitioners. So, at this stage, although the writ petitioners have had challenged, had prayed for orders for setting aside and quashing the advertisement dated 2004-23, at this stage, they do not wish to press the said prayer as they have already participated in the advertisement. Stop. Their only grievance before the court is that the authorities should consider their grievances ventilated through the representation dated so and so, and consider giving them preference of weightage at the time of passing appropriate orders for recruitment as Gaumpuras. Stop. The council appearing for the revenue submits that the results have not yet been declared and the representation has already been is already placed before the government, and the government will pass appropriate orders if found, if considered reasonable in respect of the writ petitioners. State Council, Mr. Goswami, submits.
Lordship, 104, Lordship. 104, that was received on 2604, 2023. It means after the advertisement also. The conditions, all the conditions regarding the
No,
selected
at this stage, they want that their representation should be disposed of with a direction that their prayers, if possible, should be
Lordship,
accommodated.
that may be.
Submits that if the petition is closed with a direction to the respondents to examine the claims of the petitioner ventilated by way of the respondents, then the same can be carried out within a time frame fixed by the court. But considering the above, writ petition stands closed, directing the secretary,
Yes, my lord.
Department of Revenue, to examine the claims of the writ petitioner and pass appropriate orders. And before the results are declared, and if they are found to be entitled to any weightage or preferences, as may have been decided by the department as a matter of policy, the same can be granted to the writ petitioners. Let these exercises be carried out within 30 days.
Yes, my lord.
30 days
From the date of.
from the date of receipt of a certified copy of this order. Disposed.
My lord, I'm sorry, my lord. So far police verification is concerned, my lord, it would be in the year 2000, my lord, 2005. That is mentioned 2023. Only 2000.
Police verification to continue.
Obliged.
There is some IA.
I
Yes,
know,
sir.
my lord, that they participated in the Malabar selection.
That is, I have brought.
They have brought the Malabar.
In view of the order passed today, the writ petition IA number 3419 stands dismissed.
Obliged.
time.
Yes, Mr. Chakraborty.
Last time also. Last time also. They took it from.
See, there is some legal urgency of his father and his family's father.
On whose behalf?
Mr. H. Burak.
It is submitted that Mr. H. Buragmai, counsel representing the SBI, is unable to appear before the court because of personal reasons. Matter stands deferred to be listed after 2 weeks. Mr. B. Chakraborty appears for the repetition.
2018 papers.
18th of June.
Yeah, please, your lordship.
Yes.
With all sincere apology, my lord, I am seeking an accommodation, my lord. I need to find my affidavit. Lordship grants me, my lord, at least 3 weeks time, my lord. Matter pertains to, my lord, he is seeking regularization, one of the period, as well as, my lord, some other benefits flowing from, my lord.
All right, Mr. Soikia, affidavit is necessary.
Otherwise, I was ready.
Someone has filed an affidavit here?
Transport department.
Transport. And you are for the revenue,
Finance, my lord.
finance department. Mr. Ayed Soikia for the petitioner, Mr. R. Goswami, R. Borpuzari for the finance department, prays for 3 weeks time to file his counter affidavit. MS MD Bora, Standing Council Transport, submits that the affidavit on behalf of the transport department has been filed. Considering the prayer of the Standing Council Finance, list again after 3 weeks. That will be in July.
They come after vacation, my lord. In the meantime, my lord, I will find my
17 July.
and so apply.
17.
There is no hearing demand.
Let the affidavit be filed first.
Inevitably file it, my lord.
On the
Hard at length, my lord. Another coordinate bench.
Sorry.
So hard at length by another coordinate bench. And the court wanted to go
It was
through
hard
this.
at length and it was parted before some other bench.
It is not written there, so I'm here.
Huh?
Your lordship. Not written there. although There was.
No, it is not written, but if you were submitting that it was hard, we can.
This is otherwise covered by the Supreme Court judgment,
Uh,
whereby the open Deka case has been set aside by this.
Upendas
Open the set aside.
for the master role.
Master role, because they were all appointed before 93 and they are entitled to be regularized and get the benefit of all that. So, but
Yes.
judgment I will provide, the judgment is there, your lordship will kindly see it. Yeah. And your lordship will kindly see paragraph 13 onwards. Ultimately, my lord, the whole history has been given and ultimately the paragraph 79, the relief has been provided. Paragraph 79. Respect of Upendas, your lordship knows, my lord, that it says that even though they cannot go for regularization of Umadevi case. The court held that the Umadevi case is not a bar. So while setting aside the judgment passed in the Umadevi, court said the persons who are prior to 93, my lord, they are entitled to all the benefits of regularization. So that is how paragraph 17 has been incorporated in the judgment. And in respect of others, the persons who have come after 93, court says there is no bar on the part of the government to regularize their service, which they were saying, madam. The court said you can agitate your matter now. But we are prior to 93.
What is the stand of the Karbi Anglong?
Karbi Anglong, my lord, Karbi Anglong, they have stated that we are serving prior to 93. So in this lead petition 3517-23,
Yes.
Karbi Anglong has filed an affidavit, and in the affidavit they say, if the lordship looks into paragraph 5 onwards, It says that we are working prior to 1987, prior to 93. In fact, they were appointed in 1985.
Para 5.
Para 5. The deponent text to state that the petition number 1 was initially engaged as master worker. 1987 was subsequently upgraded to the post of Khalasi in 1985. Temporary for a period of 3 months. It was clearly stated in the order the appointment was for 3 months and was liable to be terminated. But they continued in service. Respect of petitioner to number 2 was initially appointed in 92, and paragraph 7, they were all working prior to 93. Paragraph 7, it has been stated that there was earlier writ petition was filed for regularization of the service of the petition. And this is not 6096, but this is, we have filed a petition, we have withdrawn it, we can revert it to refile. That is how we have refiled it.
Mr. Chutia.
And in respect of the other case, because of 2012, the government has filed it because of the 2012 office memorandum. The government said that you cannot be regularized. That is of the open streets. That memorandum has been set aside by the Honorable Supreme Court. The open has been
Which memorandum?
That your lordship will kindly take that other next item.
Second.
Second is 624 and affidavit filed by the government. And page 36, I think. And on that.
36.
Yes.
This was set aside.
This was set while setting aside the open class, because this is on the basis of the open class case and Umadevi.
No, was it set aside or now it will have to be deemed to be not effective in view of the.
I'll for paragraph 30, your lordship will can see several petition filed assigning validity of the OM dated 2012. Paragraph 30. And single judge allowed it. Allowed regularization. Paragraph 31. But the division, government filed appeal to be the division that was set aside. Court said that in view of the Umadevi case, they cannot be regularized. Paragraph 31, your lordship will find that the single judge quashed the order with the office memorandum with the 2012.
Yes, Mr. Sutia.
In this case, my lord, we have filed the affidavit in our affidavit, we have stated in which did the petitioner joined as a master rule worker. As the my lord, Sukendra Bhattacharya case is there, my lord. As per that judgment, my lord, that is required to be considered by our regulation by the government, my regulation part, as it is prior to 1493. The department was transferred to us in the year 1995. So it is the government is required to take a decision about
Government
regulation.
would be the state.
State matter. Not bad.
Who
Regulation by
represents the state, Mr. Bor?
Yes.
This appears to be.
Earlier it
Huh?
was represented.
No,
by-
one is PWD.
Earlier it was
My case is EAC. Item 20.
One is item 20 is PWD.
not demanded.
20.
for PHE?
Why appeared last month? He said he will look into the judgment of the appeals court.
All right, we'll call up again at 2 p.m. 2 p.m. PHE and PWD at 2 p.m.
So Gogoi was informing.
Yes, it's about the process of processing of the pension.
The position, Lordship, the position is that for granting pension, Lordship, as sought for the letter. The
27, 426 of our
Yes,
mechanic.
it is forwarded to AZ, Lordship. Dated 1405.
What are these bunch of documents?
Late submission.
Has it been submitted or not?
No, that was submitted to the AZ, Lordship.
Oh.
It is forwarded to AZ.
Then AG returned it back earlier. Earlier it was returned back.
Yes, earlier it was returned back.
Then you have resubmitted again.
The phrase on it is last month. The month of May.
Okay. AG. Okay. Mr. K. Mazumdar for the petitioner, Mr. J.K. Goswami, additional senior government advocate, submits that as per instructions received, the papers of the petitioner have been submitted afresh by meeting all the queries to the Accountant General's office. On when was it submitted?
It was for on 14, Lordship, 1405.
On 14th of May. Mr. B. Chakraborty, Standing Counsel, Accountant General, submits he will obtain required instructions. How much time you require? 1 week. Or at least this matter again on 12th. 12th of June. Mr. Goswami, you can take back the papers.
Lordship.
Much obliged.
May I please, Your Lordship? So this is the second round of litigation for enforcement of the earlier order, my lord, of 23rd of April 2015, my lord. And in that case, in this writ petition on 4th of February 2026, it was specifically directed that to finalize the appointment within 10th of April 2026. And compliance report was to submit on 24th of April, my lord. But till that, they are defying the court's order, my lord. No appointment has been done till today.
Why have you come back again? Because this order still subsists.
They are not complying, my lord. Therefore, we came in the second writ petition. And in this case, on 4th of February 2026, if your lordship ever look at the order in this writ petition, at page 5, para 12, so specifically directed that since there is no dispute for the present that the petitioner was one of the candidates who was required to be appointed on the ground of physical disability and who also belongs to the SC category, and also keeping in view the fact that there are presently vacancies available for appointing the petitioner, this court directs the concerned authorities in the education department board
So what is being done now?
now to appoint, my lord.
On the earlier occasion, Lordship, it is directed to provide the checklist of number 10 by the finance department. This is the communication where the checklist is provided, and now the secretary education department forwarded it to finance department for their approval.
So, and on every occasion, they come up with a new flimsy grounds, my lord.
Is there anything to submit that once an order is passed by the court, unless complied with,
My lord,
it loses its effect and a fresh order is called for?
my lord, as there was no chance for contempt proceeding, my lord, its time has been burdened.
Then does it mean that we'll keep on passing orders again for enabling you to come and file a contempt petition?
But the second writ petition is maintainable in enforcing the earlier order
Where is, under what provision?
under 226.
Why? 226 is not the executing court of an earlier order passed, unless there is a sequel to be maintained.
But whatever order has been passed, rightly or wrongly, but the order dated 4th of
No,
February.
you're right.
2026,
It has
my
to
lord.
be complied with.
Yes, my lord.
But we're asking you why another order is necessary here.
Because they are not complying till it's
Why
more
are
than
you
10
not
years.
complying? Who's required to comply with this order?
It's education department.
For that purpose, the finance
We
approval
can
is-
convert this into a contempt. There is no bar. We can use our powers of contempt
Yes,
for
madam.
violating the order. Why is it not being done? There is a clear-cut order, no appeal, no review. The orders are not being complied with. Why? Give us a good reason that yes, it is because of X reason, Y reason we are unable to comply with. Sitting over the order, that makes nothing. We'll have to call your secretary. Why is it not being complied with?
Lordship, for that, I have to take instruction, Lordship.
You have been given time after time after time.
Lordship, one more.
They need to comply the order dated 23rd of April 2015, my lord. It's more than 10 years.
We'll give you 1 week. Please give us instructions why this order has not been complied with. If not, then we are invoking our contempt jurisdiction. List on 12th of June, by which date the Standing Council Education will apprise the court as to what steps have been taken to comply with the order dated so and so. What is the order?
My lord, on 4th of February 2026.
What is the order passed in the earlier
To appoint the petitioner in the post
date of the order?
23rd of April 2024 at page 29, my lord.
23rd of April
2015.
2304/2015, passed in WPC 1424 of 2011. And the reasons as to why the order has not been complied with. Failing which, court will pass consequential orders against the erring officers. Yes.
That's all right.
We wanted to dispose of, but I don't, some time will be taken. So we propose to refix it on 23rd June. Before the vacation, we dispose. It will be relisted on 23rd for orders. Debut.
That office memorandum has been discussed. That office memorandum has been discussed at page 52. This office memorandum was set aside by the learned single judge.
Petition.
In a little manner, 2012 OM appears to have been designed in a manner that effectively defeats and dilutes the very object and purpose of the cabinet decision dated 22nd/7/2005. Once the cabinet had taken a considered decision and acted upon it for a large number of employees, it was incumbent upon the state to act in furtherance thereof fully and not to introduce measures that undermine or circumvent. The state which is expected to act as a model employer cannot be permitted to resile from or seek shelter against his own decision through a subsequent executive decision. To allow such a course would be contrary to principles of administrative fairness and consistency and goodwill. Now, if your lordship comes to page 75, para 75, Bholanath, Jaggu and Sipal and Dharam Singh case has been discussed. Ultimately, paragraph 76, it says, what appears from the principles enunciated in the aforesaid decision, it is that the state cannot rely upon mere form of engagement to deny fair and equitable treatment to employees who have served it for long years. The consistent thread running through this judgment is that Umadevi cannot be invoked as a blanket barrier to justify prolonged and continued engagement of a temporary or ad hoc nature, especially where the employees have been discharging essential and recurring functions of the state. The court has repeatedly emphasized that the distinction between illegal and irregular appointments must be kept in view, that long and continuous service is a relevant consideration, and that the state as a model employer is under a constitutional obligation to act with fairness, consistency, and reasonableness. The practice of retaining employees for decades under deceptively titled designations while simultaneously extracting regular work integral to the administration has been disapproved consistently. Applying these principles to the present case, it is evident that engaging workers on master roles was a consistently employed policy of the state, which continued for prolonged period of time. The appellants were not engaged for sporadic or seasonal purposes, but were taken on master roles and have rendered continuous service for decades in departments performing regular governmental functions. The state itself acknowledged the magnitude of the issue and framed a cabinet policy to regularize similarly situated workers, acting upon in respect of nearly 30,000 employees. In such circumstances, to deny consideration to the fraction of the remaining eligible workers, including the appellants, by taking shelter under a rigid reading of Umadevi case would defeat the very principles of fairness and non-arbitrariness that this court has consistently upheld. In the aforesaid backdrop, we are unable to accept the contention of the state that the appellants cannot be granted regularization on the ground that they were not initially appointed against duly sanctioned posts. The state, having engaged the appellant prior to 93, utilized their services continuously for decades, and having itself framed and implemented a cabinet policy regularizing nearly 30,000 similarly situated workers, cannot now exclude the appellants by taking shelter behind a rigid or technical reading of Umadevi case. In absence of any cogent distinctions or reasoned decision justifying such exclusion, the action of the state is manifestly arbitrary. It is consistent with its obligation to function as a model employer and does not withstand scrutiny under Article 14 of the Constitution. Paragraph 79, in view of the discussion made therein above, the impugned judgment dated so and so passed by the Upenda's case, division bench cannot be sustained and is set aside, and the judgment of the learned single judge dated so in this affirmed. The learned single judge has set aside that office memorandum dated 2012. Consequently, we pass the following direction. The appellant shall be treated as regularized in service in terms of the cabinet decision dated 22nd July 2025. This cabinet decision dated, your lordship can see at para 17, page 13. that cabinet decision. That decision was taken to regularize master role and workers employees. That was the decision. Your Lordship, you can see that page 13 of the judgment. And from the date on which similarly placed 30,000 employees were given benefit of the said cabinet decision. The state of Assam shall identify and verify the eligible appellants and where necessary create supernumerary posts to facilitate their regularization. Upon regularization, the appellant shall be entitled to all consequential benefits, including fixation of pay in the regular scale, continuity of service, and all applicable pensionary and post-retrial benefits in the same terms as were extended to similarly situated 30,000 employees. In case of retired appellants, they shall be granted notional regularization with consequential monetary benefit in arrears from the relevant date until their superannuation for the purpose of recalculating pension, gratuity, and terminal dues. In case of deceased appellants, arrears and other benefits shall be released to their legal heirs in accordance with law. The entire exercise, including the calculations and payment of all financial arrears, shall be completed within a period of 1 year from the date of the judgment. We make it clear that the benefit of the above direction shall only be applicable to the appellants who were working in the departments of the states before the cutoff date prescribed in the cabinet memo dated 22nd July 2005. That is April 2013. April 1993. So therefore, my lord, these petitioners having been appointed prior to 93, as long as my lord from 1987 onwards. So I pray my lord, your lordship will give the same benefit to the petition.
Yes. My lord, my seniors read out, my lord. But the common thread throughout the judgment, lordship, was the conclusion part, para 79, the conclusions, the directions given, my lord, that sub 7, Roman 7 is very clear. We make it clear that the benefit of the above directions shall only be applicable to the appellants who were working in the departments of the state before the cutoff date prescribed. The judgment itself is very clear, my lord, from to whom this benefit can be extended. Who are only the appellants? It's not in something in RAM, my lord.
If I would have been in appeal, my lord, I would not have come here.
What else is there? I mean, are you saying that this is set aside only vis-a-vis the writ petitioner?
Yes. This is the
What is the distinction between judgment in rem and a judgment in person?
in RAM, my lord, is who are the
This particular
person.
notification has been, the judgment has been interfered.
But the direction is very clear. My wordings are very clear. We make it clear that the benefit about direction shall only be applicable to the appellants. Appellants who are working in the departments. And that apart, my lord, since
That's all right.
my lords,
We can issue supplementary directions on the basis of the
in that
judgment
case,
if
my
there
lord,
is other similarly situated.
my lords, in that case, my lords will grant me some time because there is something very serious, and without affidavit, my lords, I would not like to press any further, my lords.
What are you? How are you going to improve your case on affidavit?
My
You
lords,
tell us
no, my
that-
lords, I'm not improving.
You first tell us that the factual matrix on this judgment and the factual matrix in the writ petition are not at par.
That is admitted, my lord. But what I these will have an effect, my lord. Let the commissioner secretary file an affidavit, my lord. Whatever is said, my lord. I, as a without clear instructions, my lord, it told me very.
What were you doing from 23?
My lord, all along, my lord, this was with the this autonomous council. And now, since the scenario has changed, this judgment has come. Authorities
You are to present the case of the department before the court in a matter filed in 2023.
My lords.
After 3 years, you are now asking for time to file your reply.
My lord, since it was because
one can understand that you want to file an additional pleadings.
My lords.
We'll give you that.
That is
the question is that on the facts, you tell us how the factual position is at variance.
For that also, my lord, that additional pleading has to be filed, my lord, because these judgment of May 21st, my lord, it changes the scenario altogether, my lord. Because up till that date, till May 2026, my lords, when was covering the field, and there was already a settled law. Now it has unsettled many things, so respondents has to file, my lord, an additional affidavit, my lord. There's no iota of doubt, my lord, similarly situated persons, but till May 20, my lords, it is different.
So you carry out the directions contained
My lord,
because
we'll file an
the
affidavit. my lords.
judgment has been set aside.
My lords,
Effect is that as if it was never delivered.
my lords, understand, my lords.
Therefore,
My lords.
the question now is that the findings of the
My
apex
lord
court
may
will be
allow the
binding.
petition. What I'm praying for, my lord, I'm going to receive some official instructions if they are agreeing to this.
You are the counsel, you have to impress on your clients to tell them what
That
is there in the
deliberation is
judgment,
going on,
how
my
will
lord,
they give you instructions,
after this judgment is
whether the
delivered, my lord.
judgment is applicable or not. It is for you to submit.
My lord, some rumblings are going on, my lord. The official capacity, my lord, we are doing something, my lord. So I need some time, man, some accommodation for today.
We cannot take opinion on the judgment of the Supreme Court. This is what my learned friend is
No,
saying.
I'm not trying to impress them. I'm saying if something has to come, if they have to, they may, whatever their stand is, I want it on affidavit, my lord. As a counsel, I will be giving any undertaking, my lord.
So you first tell us whether the stand of the department is at variance in view of the averment.
No, my
made
lord, we
here.
cannot go beyond this Supreme Court order. But my lord, till May 20 it was different because we are protected by Upendas. Nothing
There
has
is an
changed.
affidavit on record filed by the executive engineer
My lord.
in 3517.
My lord, these executive engineer is not a state, my lord. It's from the Karbi Anglong Autonomous Council.
No, it is by the executive engineer.
Engineer, PhD Diffu Rural. So he is, we are not the authority above him, my lord. He is under the control of the council.
He is your employee, maybe working under the council, but
My lord.
your employee.
So, my lord, I'm just praying for the short accommodation, my lord. Whatever comes, my lord, let it be an affidavit. Because if Lordship another sees the judgment, Lordship will see the undertaking.
The petitioners were employed prior to that cut-off
Yes,
date.
93, yes.
93.
Admitted, but
If Lordship goes to para 26, then my lord, para 67, para 72, undertaking has been discussed and importance and the sanity of the undertaking. So I don't want to.
What undertaking?
My lord, those in those cases when in paras, para 26, my lord, in the aforesaid proceedings, learned additional AG appearing for the state submitted that such a policy. It started with like that, my lord.
This will govern
Yes.
the petitioners.
No, my lord.
also.
So I don't want to be in a similar footing with this gentleman, my lords. I don't want to be, my lord. So I want something to come in concrete. I don't want to give any undertaking that we will comply.
If they have not come, they have not come. It is a 23 petition. What were you doing for
My lord,
3 years?
I have.
Are you saying that was there any advice that no affidavit is required in view of Upendas? Obviously, I
no, my lord, since they were
like to believe that perhaps no such opinion was done.
because Upendas was already covering the field, my lord. Now it has changed since May 21. My lord, so I need some more time, my lord. Just a week or 2 weeks time, my lord.
You will have to examine their verification.
Well, examine, man, everything, man. But that very statement, my lord, without their official affidavit, my lord, I'm finding hard to, my lord, impress upon. It will be more proper if the.
We are not giving you time to file affidavit, but we'll give you time to go through the judgment properly.
My lords.
And apprise the court.
My lords.
We'll take it up next Tuesday.
My lord,
which is
next
9th.
Thursday will be possible.
Let us keep it on Tuesday. Let us find out if you've had the time to go through the judgment or not. You apprise us.
My lords.
On 9th.
Thursday, my lords. I have some other matter.
It be other matters. We are
tied up, man.
We are on the question of.
I understand, my lord, but since it will be.
No. Let it be on 9th. You are there. If you are not available, you request your colleague to be present. You are representing a department.
My lords.
Mr. Das, let him.
yes,
Let us give him the benefit of going through the judgment.
Last occasion also the similar thing also.
No, the judgment was not produced.
Yes, it was produced on last day.
No.
It was not taken by the learned.
No, the judgment was not produced.
Right.
Or at least, of course, we don't know whether it was not before this court.
And then for exactly for the purpose of my lord taking instruction only, he took time. My learned friend was.
There's nothing indicated in the order.
Not indicated. Well, your lordship may fix it on Tuesday.
Right. Mr. B.D. Das, Senior Counsel, assisted by Mr. Lotha, submits that the claims of the writ petitioners for regularization and the benefit of grant of pension was rejected by the authorities time and again by placing reliance on the judgment of the division bench of this court rendered in Bendas, writ appeal 45 of 2014, quoted in so and so. Stop. It is submitted that this judgment came to be set aside by the apex court in civil appeal number 4514 of 2025, Sukendu Bhattacharjee and other similarly and other connected matters. Stop. It is submitted that the question of the claim of the master roll workers for regularization and their pensionary benefits have been answered clearly in favor of such employees. Stop. The petitioners being similarly situated, they are also entitled the benefits as have been held by the apex court in the said judgment. Stop. Mr. D. Gogoi, learned counsel representing the THE, submits that he likes to, he prays for a short date to complete his instructions in the matter. As also Mr. R. Dhor appearing for PWD and Mr. G. Sutia, Senior Counsel, appearing for the Pronomus Council, Karbian, has agreed to apply counsel for the parties, list this matter again on 9th of June.
For further hearing.
For further hearing. Yes.
It's a matter regarding the implement of petition laws.
Implement.
Lordship.
The Director of National Health Mission, Lordship, they filed an IA, Lordship.
Where is the I?
When was it filed? I think that.
1798. You are praying for implement of Director Health Service,
No, Lordship, National Health Mission.
National Health Mission,
Attachment-
Mission Director.
Yes, Lordship, Mission Director, National.
Attachment number 7. I may be allowed to file post title.
Any objection?
Lordship, I am not appearing on behalf of NHM, Lordship.
Who is for NHM?
Lordship, A. Bora, MS A. Bora's name may be recorded, Lordship. Their name has
Heard
not been.
Council, the I, heard Council parties. It's an application seeking implement of Mission Director, National Health Mission. As a party respondent with the accompanying writ petition being WPC 605 of 2025. So the claim of the writ petitioner in the accompanying writ petition is towards regularization in the posts of auxiliary, nurse hyphen midwife within bracket E&M, in which posts they are serving since 2006. Stop. They are employed under the Algapur Block PHC, the district of Hailakandi, Assam. It is their claim that although they had rendered services for 20 years, their services have not been regularized. Stop. The learned counsel for the applicant submits that the petitioners were employed by the NHM.
Yes,
And therefore, by oversight, the director NHM would not be arrayed as a party respondent. And the said respondent would be necessary for granting full relief sought for to the petitioner, the event the writ petition is allowed. Under such circumstances, the IA has been filed. Accordingly, Para Mr. D. Upamanyu, Learned Counsel, appears for the Health Department. He submits that NHM is represented by Ms. Ebora. So, Para, considering the submissions made and the pleadings available to the court, this court is of the view that the prayer of the petitioner for implement of the National Health Mission can be permitted without issuing notice at this stage. No prejudice would be caused as the proposed respondent after implement would get an adequate opportunity for filing their response. Accordingly, I stands allowed, disposed. Petitioner will file amended course title. I stands allowed, disposed. National Director Health Mission is arrayed as party respondent number 7. Petition course title will be the registry within 1 week. Petition should be listed thereafter. And in the writ petition, you write, in view of the IA, order passed today in IA number so and so. National Health Mission is arrayed as party respondent number 7. Petitioner will file amended course title and the matter be listed thereafter. There are 2 writ petitions.
Yes.
You're filing it in only one. There,
I'm fine.
in the second writ petition, counsel appearing for the petitioner seeks liberty to file affidavit in reply. Prayer made is allowed. List again the month of July on a date to be fixed by the registry. Date should be fixed. 22nd of July.
Hello there. Advertise, my lord, 299 post of PP, XLPP and SLPP.
Well,
And the petitioners were expected.
before my last year starts, I have a submission. Well, in fact, the petitioners have filed a representation at page number. In the petition, they have the next at page number 59. And in our affidavit, we have said that representation is under consideration. It is under process. But that process is not complete. And I have taken the instruction. Some time is required if I pray for taking up the matter 2 weeks after 2 weeks, so that in the meantime the final outcome in the representation, if it is considered, ultimately probably the grievance of the petitioner will not be there. At page 59, kindly see the representation they have filed before the authority.
What do you say, Mr.
My lord, actually, my lord, if you also see, the list was published up to 45 persons. And our names are appear, my lord, at 75, 81, 116, 2.
No, what do you say with their
My lord,
submission that it is under consideration?
that would have been, my lord, on the wrong date, my lord.
Para 11, we have stated in the affidavit that
But the affidavit was also filed, my lord, in March, 30th of March. We have also, my lord.
You have scored higher than some candidates.
My lord, yes, my lord, our position is much higher.
People below you have been appointed.
No marks were appointed, but our in the select list, my lord, our serial number is 75, 81, 116, and 211. 245 list. And there is no advice,
And people below you have been appointed.
in fact, after police verification is a part. After the police verification, the petitioners are not selected. The list, whatever the petitioners are, they have stated that they were at some serial number, that is not the final list. In fact, 245 it is their case that 245 persons were incorporated in that particular list, and police verification have been sought for all the candidates. It is a part of the selection process. After completion of the police verification and all other requirements, the appointments were given.
So what is the reason for not appointing them?
Let the representation, in fact, in the representation, they have agitated that, and it is before the authority, it is under consideration. Kindly take up.
You have filed your affidavit also.
Yes, in para 11, we have said, page 67.
Para 8 also your losses may see, madam.
Yes. Para 11, page 67.
So then tomorrow you will say that their claims are rejected and the writ petition becomes infructuous.
No, I'll not say that. Lordship may keep the matter pending.
No, we can keep it pending, but
Yes,
once you reject their prayer, for whatever reason it may be, the writ petition will be infructuous.
So they will get an opportunity to regard to that.
Of course they will, but
Lordship,
is it necessary for litigants to come to court every now and then?
the police verification.
You only have to tell us why they were rejected.
Well, in fact, in para 8, we have said that police verification, they
So
have,
if you have some adverse remarks, adverse information regarding police verification, show it to us.
well, that's true. They may have some reservation, why they are not placing it in the affidavit, because
We are not asking you to place it on affidavit. Show it to us from your records for our satisfaction that yes, there is something.
yes, that also I can.
Otherwise, you are asking the court to sit on this petition while the department will take its time to dispose of the representation. It is rather.
No, in fact, we have stated whatever the process we have undertaken in paragraph 8.
At
We have
paragraph
taken
11, you have made a clear statement that the matter is under process for appraisal and decision of the competent.
Yes, that representation, because
Now
they
the
have.
question is that for how long? Filed in March
Well, in
26. We are in June.
in fact, because of the
All right, elections and
recent 2
new
months.
government, etc. All right.
Lordship,
Now you tell us that what is the decision arrived at by the government?
that I have spoken. Kindly keep it after 2 weeks. In the meantime, I'll apprise them.
Then we dispose of the matter, directing them to inform you the reasons instead of keeping it pending.
Yeah.
That-
I think under the legal, whatever it may be after 2 weeks, madam. I think it-
Mr. Ian Sai was a senior counsel assisted by Mr. M. Sai. Mr. D. Nath, the senior government advocate representing the respondent, submits that the representation filed by the petitioner dated 29/1.
Yes, 29/1.
29/1/2026 is under consideration before the competent authority. And however, no final decision has yet been taken. The counsel for the petitioner, the state council submits that if the matter is relisted after 2 weeks, deferred for 2 weeks, then you'd be in a position to apprise the court about the decision taken by the respondents. So, such prayers made. It's constrained to defer the matter to be relisted again. 16th? On 16th of June.
Yes.
By which time the respondent will apprise the court. With regard to the status of their representations filed.
So interim order is still.
Interim order passed earlier will continue until further notice.
Lordship may kindly see. Order dated 15/5/2026.
20.
15/5/2026 and thereafter 25/5/2026.
Yes, why has he not been allowed to join after the promotion?
That is, my lord, after my lord research from the my lord special code, against this order, my lord, the government has filed a cumulative revision petition. And in the cumulative revision petition, notice was issued and that is pending.
Is there a stay?
Yes.
Is there a stay with regard to the process? And hold on to an order passed by the department.
That should have been not allowed. See, in our affidavit, my lord,
That is not a ground.
our affidavit, my lord, is 89. That you can read. Affidavit filed by the respondent number 5. 89. There's a condition, my lord. Next, A. In the appointment letter, my lord.
Yes.
30th January 2024, the following qualified ASI head constables, the ASI who have successfully passed the departmental examination held on 7 January 2024 are allowed to officiate in the rank of sub-inspector or police temporarily in the usual scale of pay and allowance and posted in the district and organization as shown against each of them. They may be promoted accordingly provided no court case, departmental proceeding pending contemplated against them and the period of punishment if any is not operative for them. That condition is there. That's why my lord,
When was the revision filed?
revision filed, my lord, I have received the instruction. Revision filed, my lord. It was a revision, my lord, cumulative revision petition 391/2026 and last listed on 30th February 2020.
When was it filed?
It was filed on, my lord. Filed 19 January 2023. 26.
19 January.
Yes, 2026.
So then, on a date when the promotion order was passed, there was no court case.
Subsequently, they came to know that, Malab, that is that, Malab.
Whatever it may be, but during that period, you have to give him the benefit.
Malab, appointment was made on 30th January 2024. The cumulative revision filed on January 19th, 2026. So, my lord, revision file before this order, my lord.
No, how can it be? This is 30th January 24.
Oh, 24, sorry.
24.
Yes. Sorry, man. So it is a revision petition filed on 26.
So you have to give him that benefit. For 2 years, you can't keep him holding until you decide that you're going to file some criminal matter. Can it be done?
In the that is the one of the criminal case, one only notices were issued.
Maybe you give him whatever the orders are passed, it will be made subject to the outcome of the criminal.
Yes.
That is true. But in the special court, that was one of the
Criminal revision filed against which order?
against the order passed by the special court.
I have a discharge, man.
You are discharged.
Discharge
That
from
order?
the charges.
Discharge, man, annexure. Page 23 of my petition. My order dated 18/7/2025.
Page 23.
23 of my petition.
July 2025. After appointment in 2024.
What about police verification and all that? Everything completed?
Completed. Charge is submitted and I have discharged from the.
The impugned order passed on page 74 on 5th of March 2024. Impugned order, that is the challenge Annexa 7, that was handing up his promotion passed on 5th of March 2024 and official court decisive on July 2025. And against this order, criminal revision petition is filed. Which order is being essayed? They essayed on page 74.
74.
74. 5th of March 2024. But it has been, the reason has been given on being released from so and so, see Dole as the headquarter Kahilipura on 6/2/2024, and he was absorbed against the existing vacancy as the organization. He was under promotion, order of promotion and posting to the rank of SIUB on 30th January 2024 of the Inspector General of Police Administration, Assam. On being joined SB headquarters, he was released from the organization with effect from 7 February 2024 PM to join at Dhemaji TEF on district transfer 7/2/2024. Therefore, this organization has received an information that a case by the anti-corruption branch PS case number 38 of 2022 under section 7A of PC Act as amended has been charge sheeted against Head Constable UB Gopal Dole, SCB PS charge sheet 41/2023 dated 30/12/2023. Immediately the matter was reported to the Superintendent of Police, Dhemaji, over phone and requested him to return back UC Gopal Dole to SB headquarters, and letter has been sent to the Inspector General of Police Administration on this matter. Further, the promotion order in respect of the Gopal Dole was kept withheld until completion of the court proceedings dated 20th February 2024 of the Inspector General of Police. Hence, this DO order dated 7/2/2024 regarding release of Head Constable Gopal Dole. When was the matter instituted against you? It was instituted in 2022. And earlier occasion also, there was a Department of Proceeding, he was reduced in rank from ASI to Head Constable.
In this case, Department of Proceeding, in this case. Department of Proceeding already disposed of before disposed of a criminal proceeding. Same sets. Then I was allowed to, challenge the matter before this noble court. And I was allowed to sit in examination.
Now this order being withheld, my lord. So on a date when this order was passed on 30th of January, there was a criminal matter pending. Now you were discharged on 24.
Yes.
25. July 25.
Then I filed a representation before the authority.
Then they filed a revision petition.
No. Then thereafter I filed a representation before the authority, informing that I have been already discharged. That representation is pending. Then thereafter they challenge the discharge order. So now at present there is no departmental proceeding, no criminal case pending against me.
So this is against him, my lord, the criminal petition. Because
this is the criminal petition they filed.
March 2024, he was kept held, and 18 July 2025, special court discharged him. So, against this order, the authority has filed. You give him the promotion, which will be made subject to the outcome of any orders passed in the that can be right. Mr. J. Ahmed, learned counsel. The petitioner is presently serving as Head Constable. Head Constable. Reducing rank.
Yes. I have pressed up.
He's serving as what?
Head constable, he was constable,
How can he be head constable?
promoter, head constable, my lord.
Head constable,
Yes, my lord. Assistant Sub Inspector of Police.
that is not head constable.
Page 34, Lordship, kindly see. The order, page 34, reducing the rank in the complaint proceeding. Page 34, order that 26.
Rank of head constable.
Yes, head constable.
Is presently serving as head constable. Pursuant to the order dated 26/7/2023, passed in a department proceeding, where he was ordered to be demoted the post of head constable from his earlier rank of assistant sub-inspector of police, Brigade UB. The petitioner's case was thereafter considered for promotion. Again, by order dated 30th of January 2024, where he was considered and promoted to the post of assistant sub-inspector.
Yes.
Sub Inspector.
Huh?
Sub Inspector.
ASI.
No, SI.
Then from head constable, how you become SI?
Because promotion was from head constable to
Departmental examination.
departmental examination. I appear in the departmental examination
Held on 7/1/2024.
and I was selected.
Direct. Page 89, my lord. That is
The petitioner, along with other similarly situated candidate, having successfully cleared the departmental examination, were allowed to officiate the rank of sub-inspector UB by order dated 30th of January 2024. Stop. Name of the petitioner appears at serial number 12. Stop. This order, however, stated that the promotion may accordingly be considered subject to there being no court case / departmental proceeding pending or contemplated against the petitioner, against the incumbent. Stop. At the time when this promotion order was issued, the petitioner was considered and promotion order was issued. There was a criminal matter pending against the writ petitioner before
Special case number 1/2.
before the before the special court. Where is that order?
Page 23. A special judge.
Before the special judge in special case number 1 of 2024. Stop. By order dated 18/7/2025, the petitioner was discharged. For lack of evidence. And the petitioner was set at liberty. Stop. The petitioner thereafter approached the authorities, filing a representation that he should be permitted to join in his place of posting in terms of the order of promotion dated 30th of January 2024. So, however, petitioner was not permitted to join the same post. However, his applications to be rejected by
No decision taken. No decision taken.
However, his release from his earlier post as head constable was cancelled by the authorities by order dated 5/3/2024. Stop.
Thereafter,
The petitioner being aggrieved has approached his court by filing the present writ petition. Pleadings have been exchanged. There are learned State Council submits that the department has filed a revision petition, criminal revision, against the order dated 18/7/2025, passed by the special court in special case number 1 of 2023, 2024, and the matter is presently pending before this court. Submitted that under such circumstances, since there is a court case pending against the petitioner, he cannot be allowed to be join his place of posting in view of the such specification in the order dated 30th of January 2024. The counsel for the parties have been heard. Pleadings available on record have been carefully perused. The order dated 30th of January 2024 considered the case of the petitioner along with other similarly situated persons for promotion to the next higher post, for promotion to the post of assistant sub-inspector.
Sub-inspector.
Huh?
Sub-inspector.
Sub-inspector of police within Brigade Armed Branch, Anand Branch, temporarily. Stop. The petitioner's name figures in the said order at serial number 12. Stop. However, the order clearly specifies that in the event of any tendency of court cases and departmental proceedings, the matter, the promotions will not be given effect to. Stop. Consequently, the release order which was issued to the writ petitioner earlier from his present place of posting as head constable stood cancelled by the appeal order dated 5/3/2024. Stop. It is also submitted by the writ petitioner, by the State Council, that a criminal revision petition has been filed. Being
Petition number 391/2020.
criminal revision 391 of 2026.
26.
And the matter is presently pending before the court. Stop. Having noticed the facts urged before this court, it is clear that the order of promotion was issued on 30th of January 2024. Stop. The criminal criminal proceeding which was pending against the petitioner at the time when the petitioner was selected for promotion was pending at the time when this petitioner was selected for promotion. Stop. Thereafter, by order dated 18/7/2025, the petitioner was discharged. Stop. Against this, the department has filed a criminal revision petition where the order of discharge has not yet been stayed as per the submissions of the counsel for the petition. Stop. Under such circumstances, the petitioner right to be considered. The petitioner's right for promotion in terms of the order dated 30th of January 2024 stood crystallized with effect from 18/7/2025. Stop. Till the time the criminal revision petition was filed, the petitioners with effect from 18/7/2025, there is no criminal proceeding or trial. There is no trial pending against the writ petitioner as the petitioner has been discharged. Stop. Although the state has filed the criminal petition, bring criminal revision, is it criminal revision or petition?
Criminal petition.
Criminal petition number so and so is pending. No interim orders have been passed or any orders have been passed suspending or interfering with the order of discharge issued passed by the special. Stop. Under such circumstances, the claim of the court is of the view that the claim of the writ petitioner is is required to be allowed, the department will forthwith permit the petitioner to join in his place of posting as sub-inspector in terms of the order dated 30th of January 2024. Stop. As the order of 30th of January 2024 itself reflects that this promotion is being made temporarily, the confirmation of the writ petitioner, however, shall be subject to such orders as may be passed in the criminal petition pending before this court by the order dated so and so so and so. Accordingly, writ petition stands allowed to the extent indicated. Petitioner will be permitted to join in his place of posting. Necessary orders be issued by the department within 2 weeks from the date of his receipt of a certified copy of this order.
I love it.
Disposed.
Apply. But in this matter, my lord, due to pardon, madam lord, I missed a file. Can I, my lord, request your lordship, my lord, can I be taken up on Thursday, my lord, day after tomorrow?
Yeah.
What's? Wait.
Let it be on 11.
Lots.
11.
11 June.
Otherwise, Your Lordship, we have already submitted our written submissions, everything done.
Refresh our memory.
Lots.
Okay.
The request made by the Mr. T.C. Sutia, Learned Senior Counsel, Senior Governor, State referred. We listed on 11th of June.
Lots.
Mr. S. Hafiz, Senior Counsel, assisted by Mr. Petition.
Lots.
Mr. S.K. Medi appears for the respondent. Learner CGC. Yes, the accountant. CGC.
Oblige.
Yes.
That, Lordship had heard it previously also. That's with respect to, if I refresh your Lordship's memory, because with respect to the ACS
Permanent resident.
original inhabitant.
Originally.
So, I have argued it on 2-3 occasions before your Lordship. I'll just take your Lordship the documents that will be convenient for your Lordship to understand what are the documents he had submitted and what was the required thing in the advertisement.
What is the advertisement again?
My advertisement is in page
36.
31. It starts
Clause
in page 31.
6F, according to you, the offending clause.
Yes. According to me, it is not the offending clause exactly. They are putting it on me. I am saying that there is no definition given in the advertisement nor in the rule. Even Lordship, in fact, previously had passed an order asking the respondent to justify what is the meaning of original inhabitant, because it has not been defined anywhere. So if it is not defined,
This is by the APSC.
APSC has filed their affidavit. They say that I have complied with all the documents verified, or whatever documents were
Who's
required.
for APSC?
APSC has filed. In fact, Lordship had stated on a last occasion they filed their affidavit.
What is the meaning of original inhabitant?
Lordship, that definition has not been given by the government, Lordship.
But you have published the advertisement.
We have published it.
Why that is there, my lord, I'll show you, because there's a rule which is filed by the government in their affidavit in opposition. My lord, may kindly see 103. Page 103 is the rule brought by the government of Assam in 2022. It is included in the advertisement because of this rule. My lord, will have it.
Yes.
My lord, may kindly see 5 in the 102 para clause 2, subclause 5. In subclause 5,
This rule is not under challenge.
no, I'll explain it to you, Lordship. Why? My lord, may kindly see D. Clause D. The candidate must be an original inhabitant of Assam. Now, she is married to a person who is inhabitant of Assam. So during when the examination happened, the document required was permanent resident certificate or voter ID for identification of the status. So she submitted a voter ID. At that time, till the time she got selected, there was not even a single question asked on that. Only after she got selected, my lord will see what was the letter which has been given to her.
But if the rule prescribes, then the rule prescribes. You have,
But
if you
my
are
lord,
offending, you
the
have to
rule
tell.
prescribe original inhabitant. Now, who is original? Because there has to be some definition: 50 years, 100 years, 200 years, 20 years, 10 years, 15 years. If they say 10 years, then she comply with 10 years. Now, there are many other candidates who got selected. On what basis those got selected and what basis I got not selected? I did not get selected. That definition does not, they don't even have a workable
Are you
definition.
saying that this was not applied in cases of other similarly situated candidates?
Similarly situated candidate, I will not say because there may not be anyone who is married like me, but there must be someone who has studied entire life outside. They must have given an examination here. Now, how will they determine who stayed here, who studied here? At one point, they say that you need to submit permanent residence certificate.
Was the petitioner born in Assam?
She married in Assam.
She was not born in Assam.
She was not born in Assam. So there might be situation someone is not born in Assam. Someone may be from Assam, but someone is born in outside Assam. Now, whether that will apply original inhabitant, how that definition will work out, is completely vague. So on the last occasion also, lordship.
Is it hit by Article 15?
It is directly hit by Article 16, but I did not challenge the, there's a reason not to challenge the advertisement and the rule, because I appeared in the examination. I was not even in a single moment I was asked or I had a understanding that rule or the clause is wrong. Now, if I appear in the examination and tomorrow I go and challenge the clause, the question will become that you have participated in the examination, now you cannot challenge the clause. So that being the reason I say that when the definition itself is not workable, it itself is vague. Otherwise, also that original inhabitant asking for that status itself is violative of Article 16. Though not challenging as a rule, but it otherwise is invalid. And the state government has filed their affidavit stating that they don't have a definition of original inhabitant. I will show it to in the affidavit they have submitted. May I show it to the lordship, that affidavit where they say that there is no definition of original inhabitant. It is filed by the
Additional affidavit.
yes, Mala. In fact, that has come because lordship has passed an order. Lordship stated that you bring a definition of original inhabitant if there is any office memorandum or if there is any rule which define original inhabitant. That was the lordship's order. And then they filed their additional affidavit. That affidavit, the pagination will be again same. So lordship will again have to go by
There are
the
5.
yes, 34/2005.
Mr. Mazumdar, is it not hit by Article 16?
But as your lordship has also put, it is there in the rule itself. If the rule is not under challenge and the advertisement is in terms of the rules itself, your lordship goes to the rule minor. Rule your lordship will find at page 103. Without challenging this rule, my lord, if the argument is that this rule is violative of Article 16, lordship goes to page 103 of the affidavit filed on 9/12/24.
Is 15 or 16?
16. 15 will be education. 16 will be employment.
So Article 16.
You are referring, sorry, you are referring to Mr. Mazumdar?
Well, page 103 of our affidavit filed on 9/12/2024, running page will be 103, madam.
103.
Madam.
Yes, the rule.
This is the rule, madam. And this is Assam Public Services Combined Competitive Examination Amendment Rules 2022. Now,
Right or wrong, the rule is there.
But how they say
Somebody
that,
will have to say that this rule is.
well, who are original inhabitant then? They'll have to give an answer to that first. Because they have selected more than 100 people. So who will be the original inhabitant in that situation? Because he got married, she
They
had lost the,
they have attempted to give a definition in para 5
that is by way of PRC.
by
But PRC is not only criteria.
no, no, affidavit, additional affidavit.
Yes, my
in
lord.
Para 5. Para 5.
Para 5,
That is page 126. of
one
the-
who resides permanently and actually, permanently as in, my lord, who will reside permanently? Because there will be so many people who might have not born in Assam. Can they say today that those who had been selected here were all born in Assam and permanently studied in Assam? Whether that criteria was applied for other candidates. This definition is absolutely vague. Lord. This
No,
definition.
they are relying on the PRC.
PRC is, had it been a case where they would have only asked for PRC, that I could have understood. The document which were asked for is PRC and voter ID. My lord will say, my affidavit in reply, it is application form 122. Page 122. Because that I am pretty much sure that other selected candidates will not have PRC, not everyone. PRC is only with respect to those students who studied here for class 12. Page 122, Lordship has my affidavit in reply. Here, Lordship may kindly see the uploaded document details. At the bottom, it says permanent resident certificate issued for education purpose. They themselves say issued for education purpose. Oblique voter ID. So any of the two documents, if they submit, that will satisfy.
Wait.
Page 122.
Yes.
Uploaded document details in a
Uploaded.
yes, that the last sentence. Permanent resident certificate issued for education purpose. Oblique voter ID. So Lordship knows that for educational purpose, that's like for getting admission in MBBS or in engineering college, the government issues PRC. That is only for educational purpose, those who
So
studied
your
here.
voter ID shows your resident.
Yes, I have a next. I have a next. If I don't kindly see my voter ID.
Where is that?
Page 25 of the writ petition. My husband has PRC, so I annexed his PRC. His father was a government servant. His grandfather was a freedom fighter. Everything has been placed to them. Page 25. The passport also I have the address of Gauhati on. Page 26, the address is given. My lord has it.
When was it issued? Voter ID?
It was.
Date of issue is not here.
It
Is
doesn't.
it here?
It
Issue date.
Issue date
22.
22.
Ah.
That was. She has a passport also. I think the one is the passport, page 24. Lordship want to see whether the
voter ID was issued prior to the advertisement. Aadhaar card also, I have an ex 27, she has the same address.
Where is the order of rejection?
That order is not never been filed by them, but that has been handed over to your lordship. There's an instruction. It might be on record. It's only an instruction to the council, which says that she is not an original inhabitant.
She's appeared for which post?
ACS, Assam Civil Service. She got 35th
For which year?
for 2022. So this matter is pending for last 2 years.
Are you sure she's still pursuing?
Of course, my lord. Civil service job. She is completely resident of it. Is not that the government is, if perhaps thinking that she has come here only for the examination. It is not that. She is a resident of the secretary.
Resident of?
Resident of the secretary area. Her husband, in fact, was classmate of mine. So they are totally, completely
We are
settled.
not asking you personal
No,
information.
no. I just said I know the personally. I'm just saying that it is not that there is some situation that someone has come from outside the state and appeared in the examination only to secure the job they have taken
Yeah,
an address.
Sir, I think we need to take a call on this. Your application form says voter ID also. Perhaps the intention was to find out some details.
The petitioner is
Now, unless in the absence of any definition of what is an original inhabitant.
or at least this much is clear that she was born in Rajasthan, studied in Rajasthan, married to a person in residing in Assam in 2013, and she has been continuously residing in Assam only from 2016. How can this be equivalent to this situation?
But without the definition of original inhabitant,
My lord,
somebody will have to define it. Who is an original inhabitant? What is the measure?
my lord, at least this much can be said that a person who was born here, who studied here, is residing from the very
Violating
beginning.
of Article 16.
My lord,
Can you debar somebody?
my lord, that is what I'm saying. It is there in the rule. Their advertisement is in consonance with the rules itself.
I accept your argument that it is there in the rule.
My
It says original inhabitant,
But
but it there is no definition.
there are two things in the advertisement. One has to become original inhabitant, and secondly, my lord, if your lordship goes to page 36 of the advertisement, candidate should be registered in the district employment office of Assam, and in order to register, he or she has to show that there is a notification.
You are reading from the advertisement.
My lord, yes,
Where is the requirement of registration?
page 36, ma'am.
36.
6 eligibility 6 E and F. E is in respect of registration in an district employment office of Assam, and F says a candidate must be an original inhabitant of Assam.
Is she registered there?
Yes,
She is registered, but she is not entitled to be registered, ma'am.
But that you'll have to cancel it. You've not cancelled it. What is the requirement of district employment? Registration under the district employment
Yes, a
office.
person has to reside here for 20 years. I've annexed that document.
Where?
Page 117.
117 is a part of the affidavit.
Yes, ma'am, the other affidavit filed on 30th of April 2025. This is the requirement for being eligible to be registered, madam. Employment services which was under the control of Government of India was.
You're reading from the affidavit.
Yes, page 117, annexure, ma'am,
117 is a part of the affidavit.
part of the affidavit.
And you get to second affidavit. 20.
Page 117, what is it? Annexure 2 of the affidavit filed on 30th of April 2025.
This is not 117, this will be 132 here, our affidavit, in our, anyway.
And
So this is the,
this is the basis for on which a person can register himself with the district employment exchange. Employment services which was under the control of Government of India was transferred to the state government and tagged with the department with effect from 1st of November 1956. The craftsman training scheme which was formerly under education department was transferred to the labor department on 1st April 1964 and constituted as a wing the Directorate of Employment and Craftsman Training under the Labor and Employment Department. Now the Directorate of Employment and Craftsman Training, Assam, is under the newly created.
she was the domicile of the state since which year?
2016.
So it will be, has to be treated like 2013. After she got married here in 2013, but then the husband resided in Delhi at that time. So they went to Delhi and 16 they returned. They have been here since 16. Now this document, Lordship, it's just a one page which has been submitted. It's a user manual. This is not a rule. This is not an act. This is nothing. This is just a user manual given in the their site. And a lot this district employment issue was never there
This
previously.
district employment must be having a set of rules.
But this is not as per the rule.
This is what they follow, madam. But any person cannot ask for being registered.
My Lord, may I kindly
And
see the
most of
supporting.
when the rule itself says that a person has to be original inhabitant.
No. Is this page 117 as per your marking?
My lord,
Is it a part of the rule?
it is not in the rule, my lord. This is the procedure they follow. It says eligibility for being eligible, any citizen who is domicile of Assam for more than 20 years or whose parents and forefathers has or have continuously resided in Assam for a minimum period of 50 years. The applicant must be having 14 years of age or more. These are the requirement.
I have to kindly see the next page, supporting document. Again, voter ID.
Voter ID is a
So how to
related
determine?
document. A person coming today and saying that I am original inhabitant, it is inconsistent, my lord.
Oh, I agree, but your definition of original inhabitant is not there.
And
You are trying to infer it.
My lord,
And
definition
this
is
is
not
also
there.
not also a set of the rules.
My lord,
One can understand that yes, employment exchange rules specify this, and you are trying to import it.
my lord, at least it is.
Somewhere, some authority must define what is
But
original
the
inhabitant.
rules are very clear. It says original inhabitant. A person coming 6 years prior to the advertisement, can he claim I am original inhabitant? I was born.
What is an original inhabitant? You have to read the place materials to suggest them what is an original inhabitant. If it is not there, at least by inference, you have to be to say that this is the meaning of original inhabitant. This is how original inhabitants were decided in a given matter.
My lord, at least the word original says from the very beginning a person is here. I am coming on a subsequent date.
But
How does she become originally inhabitant? From which angle?
no, so by this analogy, what is happening is that you are asking people of Assam not to get married to citizens who are not
at all.
original
Well,
inhabitants.
not at all. By marriage,
And more so, you are asking their spouses
Right.
of the original inhabitants not to get employed in the state. I mean, under what provision of law are you bringing this analogy? Yes, you may have a right to say that yes, original inhabitant, it is there, not there. subject to the same being tested against Article 15, 16. But at least some definition must be there. What is an original inhabitant? This is how we have defined original inhabitant, and this is how it has been decided in such case. But merely by giving a definition, you are an original inhabitant. The term original inhabitant must have been taken from some.
In the context of Assam, this expression assumes a
This
huge
expression,
importance.
that's right.
Very
So
serious.
all the more
This
reason
is a
that
very serious, this is the definition which is.
this expression is not only serious, it can have very, very far-reaching consequences.
Yes, ma'am. Yes.
Therefore, it is necessary to at least define what do you mean, what are the parameters to decide who is an original inhabitant. Now, just suppose this with the central services. There are many central services officers posted in Assam. They are not original inhabitants, but they have spent their larger part of their careers in the Assam, Meghalaya, Kerala or something. They have spent their lives without being original inhabitants. They are also civil servants.
Then employment under the Union of India.
That's right. So what you are asking for is the parameters to see whether a person be competent and conducive to render services in the state civil service. You have every right to choose your method of selection, but to the extent permissible by the Constitution. We are not questioning your methods. All we want to know is that by the definition, by the parameters which you have laid, how do you define the parameter? Supposing you say that so and so must be a major, that you must be a major to make an application. Now, who is a major? The law defines who is a major. So, similarly, somebody who must be a member of the reserve category, you know who are the reserve categories, what parameters are necessary to satisfy. Here you have laid down a parameter which you have not even defined. Unless you define it, and at least if you can lead some materials to show that yes, this particular analogy has to be drawn, define this. It appears to be in conflict with Article Constitution of India.
The other part is very clear for registering one with the district employment office.
That also is not a part. That's what I'm here asking, that whether employment exchange has a set of rules which define this clearly. Mr. Goswami can help us to find out whether your is it there in the rules? Provide and give it to the council there. What does the employment exchange say?
I checked it. No,
It's not there.
The employment exchange follow this this policy. Policy is that the person.
No, policy. That's what we are asking. Is it a policy?
Yes.
Policy laid down by which notification?
So that's the eligible criteria. Lordship, so far, council stated, Lordship, senior council stated that this is the eligible criteria that was adopted by the government, Lordship. And that record,
this eligible criteria is defined where?
Yes,
is it a part of the rules?
Yes.
Is it a part of some notification?
There is a portal for registration of.
Who has put it in the portal?
Yes, the department.
Huh?
The department.
So who has authorized the department to frame a rules of its own without publishing it? It must be gazette notified.
Yes, that.
You can't tinker with the rules.
Yes. That
If the rules are there, then it has to be notified. Yes. Portal will not supplement the rules.
But if it is not rule, it is a user manual and conflicting with the constitution, I don't have to go to challenge that thing. It is absolutely unconstitutional, the user manual. Putting that criteria.
So we
also.
don't know whether you have to challenge or not. We're not on that. We are trying to understand if there is any
It is
source
not
by which the definition they are trying
So far,
to incorporate.
Well, we'll find out from the department what basis they have created the portal.
It is time we finish this matter because
Yes.
this way or that way we have to finish it. We are keeping it hanging for how many years now?
2 years.
2 years.
The
Person is
next batch has
awaiting.
also come.
Huh?
The next batch has also
Next
come.
batch
They
has
have
also come,
come.
assuming we allow the writ petition. What will happen to the claims of seniority?
I kept the interim order for.
There is an interim order
Lordship has granted interim.
saying
Saying no post to be filled and also
so no post to be filled is okay. Supposing we allow it,
consequential.
then without working, she'll have to be given the seniority. Only because of the delay.
Let me find out.
If government would have come with a definition, then definitely married women, they must have included. Merely because the definition clause is not there, that's creating all the confusion. Otherwise, it will be so arbitrary that not even a single person outside married will get an employment here. Lordship had put that question rightly. No one will get it because the age criteria is 38. So one has to get married at the age of 15 to get an employment. Child marriage, otherwise not possible.
Why not this argument subject
No,
to
absolutely not possible. No one can get
this is
employment here.
absolutely absurd. A person, in order to get employment somewhere, he goes and marries someone.
Not only to get an employment, no one has gone here. No one has come here.
That is an absurd argument.
No one has come here to get employment.
No one can become eligible to apply somewhere by way of marriage with a person residing. That is different.
But you have to give us a
your lordship is
definition
right.
of
Yes.
original
Yes.
inhabitant. Then original inhabitant.
From the department, we find out what is the basis for putting up in the portal, number one. And as far as domicile, original inhabitant is concerned, based on some certain case laws, I'll try to justify that a person coming here and staying for 6 years cannot claim to be originally independent.
My lord,
If it is a part of the rules, it could be there with a
in the rules, it is not there, my lord, that is it's not defined in the rules.
Because it will have no meaning now, but at least to find out was there any attempt to give a definition in the cabinet memo
my lord, may I kindly see
prior to the rules being framed.
One area where it has become difficult. Various authorities at various levels may not have tried to define this, and
So, just
for
thinking
at
aloud.
least this much, I am arguing with responsibility that when the expression original word is there,
Then-
your lordship is correct.
then you'll have to say that 10 years, 15 years, minimum 20 years, you have to say something.
No, man, what I'm saying is the word origin at least says there from the very beginning, meaning thereby that if you are born here, then you can say I am an original inhabitant. You are not born here, you studied elsewhere, and 6 years ago you came here and now you say that I have to be registered with the district employment exchange and I claim to be an original inhabitant of this place. Original inhabitant, it's very use of the word original says that you originated here. Subject to, my lord, ultimately what your lordship decides.
my lord, they passed an order on 23/1/25.
I am married to a person who is an original inhabitant. That will not change your character. Your lordship knows the Supreme Court judgments are there where a person marrying a scheduled caste or scheduled tribe doesn't by virtue of that marriage become a scheduled caste or scheduled tribe.
My lord has passed an order on 23rd January 25. Order lordship has asked the same question which is asked today. The same question was asked 1 year before.
My lordship will fix a date matter on the next day.
Then
Come
the
up with
affidavit was
the
filed.
basis on which it has been put up in the portal. And as far as original inhabitant is concerned, I'll try to discuss this on court with some case laws. But there are some case laws, and
Yes.
I also say last one thing, Lordship. This district employment exchange board registration has been brought up now. It is not that at the initial stage, the respondent has stated anything on district employment exchange. Initially, it was PRC, subsequently original inhabitant. Then when there is no answer, then the last affidavit, they said the district employment exchange. So every time they are improving their case, and which is at all not permissible to improve their case again and again. Because they don't have a definition of what
But
is.
on the contrary,
Lordship.
if we go by the dictionary definition,
Yes.
what is an original inhabitant?
In that case, Lordship,
There some inference can be had that yes, you were born and brought up, or you spent a sufficient number of years to be included.
because what happened domicile. For example, if someone wants to say that the domicile, her original domicile of Rajasthan is completely changed now. She has shifted to Assam. She will be staying here. So her children will be from Assam. Everything will be related to Assam only. She will have a her family
No,
property
if
right
it is
also.
a-
Everything
if it
she
is a-
will have.
if it
So
is a
becomes an
case-
inhabitant of
If it is a
Assam.
case for her children, then perhaps the definition, no further inquiry is required to be made.
Required. I understand, but Lordship, without the definition, that creates a problem because otherwise, had there been a definition, we could have challenged it before the examination only. We could have challenged it saying that this is while directly violating Article 16. No one has given any clue to us, not even a single hint that will be treated like in this manner.
Tell us when we have it. We should close this matter.
Yes, yes.
My request, Lordship, next week, if possible.
Mr. Mazumdar, tell us.
Let me have a couple of weeks. 16th, Tuesday.
16th is fine. June, right?
16th.
16th is
Right. For further hearing on 16th. The joint request. 16th of June.
Well, interim order.
Interim order passed earlier, will continue until further orders.
My request, Lordship, may explain what the whatever definition or whatever is Lordship has requested.
You wanted it to be a part of the order.
If
Not necessary, because these are questions which are arising in our mind. We are asking you, we are being a little candid, but what ultimately comes.
earlier.
We have a partner matter. So we'll refix this matter on some other date after vacation.
One point is while issuing the second so-called notice, the inquiry officer had already expressed his mind matter, which is not permissible.
Then
Redetermination of the. And I have been.
16th, we'll have it on 16th.
16th June, my lord.
Item number 33.
33.
We released it on 16th of June. The attempt will be made to dispose of the matter.
Deeply agree.
Yes.
16th. Deeply agree.
Yes.
On 12th of May, this Honorable Court heard my matter regarding the three core issues. One is the transfer. violation of the transfer order. Another one is issuing of the show cause notice without having any authority. And the third one is the lordship taking the rights of disciplinary authority for issuing the memorandum of charges without having any authority. On 12th of May 2026, the respondent side mentioned that they will going to submit some document to justify the illegal rights of discipline. They could not, though they mentioned in their affidavit in opposition that after the violation of transfer order management, that is the MDNRL, allowed them to continue my duty. But that kind of allegation was never imposed during the disciplinary process. They could not produce any document in this honorable court for last 3 years that MDNRL allowed them to continue my duty after the violation of transfer order. The violation of transfer order was done by them. They themselves violated the transfer order. They themselves invalidated the transfer order. It is a broken foundation. So I specifically mentioned even in the show cause reply that this is the release order was in violation of HR circular. So I need not to
Violation of?
HR circular. There is another separate HR circular.
According to you, the person who's initiated the proceeding is not authorized.
Not authorized. At that time, MDNRL was my disciplinary authority. MDNRL did not take any action against me. My reporting authority was also at the new location did not make any communication against me. The respondent, Mr. Subroto Das, himself highlighted
all these problems, all these issues, you should have urged before the disciplinary authority when the notice was given to you.
Yes, Lordship, there is a misrepresentation, Lordship. They mentioned in this honorable court in the affidavit of petition that my representation against the transfer order was were rejected. Kindly allow them first show that my representation against the transfer order before the release. I submitted 3 representations. Out of that 3 representations, 1 is email, another 2 is 2 numbers application. Kindly allow them first show that out of that 3 representations, they by making any communication, they cancel those representations. Second issue, they mentioned that after the violation of transfer order, MDNRL allowed them to continue my duty. Kindly allow them to show by their records that any kind of approval they have submitted in this honorable court to show that MDNRL allowed them. Thus, third one is by taking what authority? They initially misrepresented and suppressed the issue by as a colorable exercise of power that he was my leave authority. But later he himself denied that he was not my leave authority when I intimated a leave. There is no allegation against the intimation of leave in the memorandum of service. And the last on 12th of May 2026, the respondent has mentioned that there are some documents to justify the illegal rights of disciplinary. The rights of disciplinary authority, there are 2 issues. One is the rank. There is no any document to sustain that the respondent number 6, Subroto Das, who was in the rank of DGM. There is no any document to establish that his rank was further elevated. That is a redesignation circular which was even clarified in various judgments by Honorable Supreme Court that redesignation is never considered as a promotion or never considered as a elevation of rank. And earlier occasion on 12/5/2026, when the issue was brought, there are two issues. One is the rank. Second is that the circular itself made a limitation and restriction that in case of exercise of power, new designation cannot be used. But they mentioned that there are some other documents to nullify this submission. But they failed to submit anything on 19/5/2026. And my issue was adjourned from 12 to 19 only based on this kind of submission from the respondent that they were going to submit some document. They will submit a list of dates. They will submit some concise notes, which they repeatedly failed for last 3 years, for last 11 months, for last 7 months, respectively.
Yes.
This four issue, if they can address, then I can further submit my.
No, you submit whatever you have to submit. Thereafter, we will ask respondents to give a reply.
These four issue, if they can address these four issue, if they
See, whether they address or not is not our concern. You have raised an issue, we'll give them an opportunity. If they don't address, we'll pass orders.
yes, or that is the issue.
Yeah.
Their statement themselves they establish that
So
their
the-
statement
so
is
the
false.
First issue is, according to you, is that the authority is not the competent authority.
First issue is, Lordship, the transfer order was violated by them to, at that time, when the transfer order was issued, there is a misrepresentation, there is a suppression of material fact. They tried to create an impression that by considering my representation, they allowed me to continue my duty. But later, in this honorable court, they denied that I was allowed. They mentioned that by rejecting my application, when the transfer order was violated by me, then MDNRL allowed them to continue my duty. I violated the transfer order. Then after that, they need to take action, but they did not take action against me. They give me an opportunity to correct myself. If they given me an opportunity to correct myself, that is very serious issue, because if a person violated a transfer order, after that he was given an opportunity to correct himself, he did not correct it, he did not hand over his job during a stipulated time period, then this is a very serious issue. This should be at least recorded in the release order, at least recorded in the show cause notice, and at least recorded during the disciplinary in the memorandum of searches. But that kind of allegation was never recorded. They are just try to make some contradictory statement just to create a problem with litigation. Their submissions are totally inconsistent. Their submissions are totally contradictory. They have made some if one pages they made some statement, then after 4 or 5 pages they made another statement.
All right. Then next.
This four issues, Lordship.
No, you tell us the issues one by one. We are writing it down.
Yes, number one, Lordship, there's
This
violation of
transfer order.
transfer order. They made a statement. Lordship, kindly allow me to read the exact page number, Lordship.
No, we'll go there. First, you tell us in short what
Yes.
the issues are.
Then
Then we'll elaborate on that.
yes, Lordship. The first issue is that the transfer order was violated by respondent number 6 along with the HR official. They mentioned that MDNI, after violation of the transfer order, MDNI allowed them to continue my duty, but they failed to submit any document that MDNI allowed them to continue. MDNI means that was already now retired. It was retired on 2022 January 2022.
Right.
So that is the first issue. The second issue is that after the transfer order, they themselves violating the transfer order, they released me on 82 days. Lordship, as per existing rule, they required to be release me 60 days, within a period of 60 days, and prior to that they require a handover and takeover instruction is required to be given to me. This is a existing rule, as well as there is a separate HR circular also, which I specifically mentioned in my show cause reply. After that, they did not impose any allegation against me that I violated the transfer order. I need to join duty at new location before 03/08/2020.
Yes.
Then the third one is, Lordship, the show cause. Thus, without having any authority, he did a colorable exercise of power. He issuing the show cause notice along with some misrepresentation and suppression of material fact. He even evoke a CTA rule which is not actually applicable. He cannot evoke that rule by bypassing the HR circular that was circulated on.
You're referring to whom? The
Respondent 6.
respondent 6. Why he does not have the power? Because he's not
No, Lordship, first of all, he, without having authority, he himself confirmed in their subsequent document, penalty order that he, without having any authority, he issuing the show cause notice. Because show cause notice was issued on 02/12/2020, but it was sent to me on 12/12/2020. He later in the penalty order himself confirmed that he get the disciplinary authority by document dated 12/03/2021. That is after period of 3 months. That is his claim, but it is totally misleading and false, Lordship, because by document dated 12/03/2021, he cannot exercise the right of disciplinary authority. That is the second issue. Then next issue is that, Lordship, rights of disciplinary authority. He fabricated allegation against me. He himself fabricated an allegation, and he himself become a judge to evaluate those allegations. At that time, my disciplinary authority, MDNR, he did not even place my show cause reply to MDNR, Lordship. Show cause was issued for voluntary abandon of company service. MDNL was the authority to approve such kind of order, voluntary abandon of company service, but he did not send those show cause reply to MDNL also. He kept on holding the issue without having any authority. When I follow up the issue, without having any authority, he issued this memorandum of charges. Later in the penalty order, only he claimed that he issued the show cause memorandum of charges by exercising the right of disciplinary authority. Prior to that, he did not confirm in any document. There is a confusion because that I immediately raised in my reply to the memorandum of charges, because the show cause notice was issued for voluntary abandon of company service. There are different provisions in company CDA rule to issue a memorandum of charges. So there are lots of confusion. That is why I, in my reply, I specifically mentioned the issue, but he did not clarify the issue. He exercised the power in a colorable way, and later he confirmed that he acted as a disciplinary authority while issuing the memorandum of charge. But he did not have the required rank, and the designation which he used to issue the memorandum of charge, he cannot issue that designation because the circular itself restricted and limited to use such kind of designation.
Yes.
And after that, Lordship, inquiry officer could not respond at any of my query. The respondent seeks himself confirmed by the mail that my query will be responded by inquiry officer, but inquiry officer could not respond to the issue. But therefore, he just tried to just shift the entire burden to me. He violating the company CDA rule. He concluded the inquiry as ex parte after 26 days by doing a delay of 26 days. That is just to shifting the entire burden to me, because they fabricated issue, they imposed false allegations which they cannot prove by doing an inquiry. And before imposing penalty, they actually threatened me that I will face this kind of issue for a period of 5 years. That is, their intention is clear that we will not going to clarify anything. If you go to the court, then we will run before a court of law for a period of time. We will not be going to give any document. For last 3 years, they are could not submit any document. This honorable court passed 4 numbers of order. They could not submit required document regarding the disciplinary process. They could not submit any document related to appellate proceedings. They violated 4 numbers of court orders.
Yes, sir.
Yes, sir. If they could submit anything, then I can respond.
Last occasion, my lord, I had handed over a list of dates. Although there is a note of submissions, my lord, I'll have to modify that, my lord.
I did not receive that. So last occasion did not hand over.
Stop dates.
Yes, Lordship, I think Lordship is rising at 4 o'clock. We have got only 10 minutes,
4:15.
4:15.
You can begin. Let us
Yes, then I'll
try
begin.
to wrap up this matter. If you have an extra copy, you can give it to us or you continue. Ask your colleague to send an email, we'll take a printout.
I can start. Sir.
You send a soft copy later, but you can start now.
Yes. I would like to go in my own way, my lord, rather than replying to whatever he has raised. I'll reply. I'd like to plus first please. First and foremost, my lord, the order of transfer is of 2020. In my respectful submission, my lord, that cannot be challenged in the year 2023 after completion of the disciplinary proceedings. So whether the lordship is now not testing the correctness of the transfer order.
Is it under challenge?
In the prayer, there is a reference. Reading scheme. Because the prayer itself is very long.
There is no any PR lordship regarding the challenging of judgment.
You don't have to reply
Please,
to every
Mr.
question.
Bora,
You'll
please,
get your-
you have got your chance. Please take
Get
your
your
seat.
Just assisting this honor.
You'll get your chance.
You will get your chance.
You
Please
note
don't
down.
interrupt like this.
I just assisting this honor.
If you permit us to suggest, note down whatever he has submitted and give a reply together. Alright?
So as such, the transfer order is not under challenge. The transfer order is at page 345.
345.
345.
Yes.
It is not a case that only he has been singled out and he has been, although it is not under challenge, but it is not a case, nobody's case that he has been singled out and he has been transferred out of Gauhati. It is a series of transfers, my lord. Maybe there is no change. In some cases, there are no changes in the location, my lord. He is at serial number 45. The entire transfer order is annexed in my affidavit at page 853. In any case, my lord, he has been transferred from Gauhati to Numaligarh. Lordship will note the date. It is 5/6/2020. The order itself says that you have to report within 60 days since there is a change of location. Now on 18/6, he files a representation at page 347. The ground is he is having a back pain. Basically, it is a medical ground that it is not possible for him to work at page 350.
Yes.
With present working schedule and posting, I somehow managing my health issue and even sometimes by lying on our department conference room table for a while during lunch break by curtailing the lunch time. As mentioned above and as per HR circular dated so and so, it is not possible for me to follow the work schedule and to work at NRMT, even for which I was transferred for this from the same department to commercial and later to marketing department. For this grateful, if you refer the content to some above mentioned applications as input. So basically, it is his health ground. He is suffering from back pain and he cannot join at NRMT. Now he files another representation. At page 353, I am not taking your lordships to all this. Again, he asks that please allow me to continue. Now, lordship will kindly come to 358. He is saying that we have not
asked him. Now, if after transferring an employee, the management has to send reminders to each and every employee that look here, you have to join by so and so date. Then the management will have to stop other works, my lord. At page 358. This is an email dated 27/8/2020. The reference circulars dated so and so, you are hereby released from your current department. You are advised to report to your new place of posting at refinery location. So he was supposed to report by 4th of August. 60 days we get. So on 27/8, having no, since he has not joined, we released him from Gauhati. Now, in spite of that, my lord, he does not go.
This release order is
27/8, my lord. The order, the date is at the top right hand, my lord. It is an email.
27.
27. Then again on 1/9, Lordship will now kindly have the list of these taken up. After that release order, my lord, on 1/9, he again files a representation to allow him to continue. He does not challenge the order of transfer or the order of release. Subsequent email dated 3/9, again on 5/9, Lordship comes to the next page.
Yes.
Page 396.
'96.
396. Here he is told, my lord, that this is in reference to your letter dated 5/9/2020 addressed to MD on the subject prayer for continuation of duty in same job and in the same location. We have gone through the content of your letter and would like to bring the following to your notice. NRL is a single refinery company with lean manpower, and transfer of officers to its refinery located at Numaligarh is a routine procedure. The letter of appointment issued to you, we may ignore this, my lord. 3. A hospital with 24 hours medical facilities run by the Vivekananda Kendra, Kanyakumari, is available inside the township to take care of medical need of employees and their dependents. There is also provision for referral of patients to so and so. And number 4, my lord, your job at NRMT is basically a desk job. Still he does not go, my lord. 14/9, another representation. 17/9, he was informed that already all your queries have been met by the letter dated 10/9. 21/9, again files a representation, this time raising a grievance against the doctors of the VK NRL hospital. And 15/10, no, well, ultimately on 2/12 we issue show cause notice. A show cause notice, your lordship knows, is not the initiation of the departmental proceeding. Departmental proceeding will start only on the issuance of the charge sheet. A show cause notice was issued asking him to show cause as to why a particular clause was referred, why it should not be treated as a voluntary abandonment of service. Because ultimately, my lord, he never joined at Numaligarh. He went on filing representations. Then in a letter, he says that I intend to take leave. But for taking leave also, my lord, he has to first join at Numaligarh. Then he has to apply for leave. Ultimately, my lord, the memorandum of charges was issued on 19/3, which your lordships get at 503. Charges are two, my lord: willful insubordination or disobedience and breach of laws because of violating the order of transfer. Now, inquiry officer is also appointed. Now, he also objects to the appointment of the inquiry officer. First, one lady officer was appointed, he objected. Taking his objection, it was changed. Then the inquiry officer issued notice. That change, your lordship, will come get at page 574, that the inquiry officer was changed. The change of the inquiry officer, lordship will get a reference at page 574, which is part of the inquiry report, that it was changed. Now, finally, the first sitting of inquiry was held on 23/7/2021, which your lordship finds at page 550. The last page of volume 2. I will do one more thing, my lord. In the page numbers, I'll give a fresh copy, my lord. In the page number, I'll refer to the volume also.
That's all right, you can find out. Enough. You can indicate it here only.
Yes, by hand. So 550 is the preliminary hearing. Now, inquiry officer explained the procedure to both presenting officer and charged officer. Presenting officer submitted the annexures of the charge sheet dated so and so to charged officer. However, charged officer mentioned that his letters dated so and so to be read as so
He
and so.
did not participate in the inquiry.
He did. Because on the very first day, he said that, because my lord will kindly appreciate, when the charge sheet was issued, in the reply, though he replied to the charges, he raised two queries. When he raised the preliminary query that please answer or satisfy as to how Subrata Das is my discipline authority. Inquiry officer said that I cannot, because I am appointed by the inquiry officer, I mean the discipline authority. He did not challenge that. The charge sheet was not to put to challenge on the ground that the officer issuing it did not have the authority. He went on questioning in the disciplinary proceeding. Second paragraph is important, madam. Paragraph number 3. Charged officer then stated that without receiving any reply to his above mentioned letters dated so and so and so and so, he will not participate in inquiry nor sign any documents. So on the next day, the witness deposed, because lordship will also appreciate that the entire inquiry is not, the facts are not in dispute. It is not a case that theft has been alleged or something is required to be proved by bringing evidence and witnesses. Here it is plain and simple manner. The transfer order is there. Admittedly, he did not go. He did not join. Ultimately, the charge sheet of willful, insubordination. Then on 19/8/2021, the regular hearing was held. Although I have said in the list of days, refer 575 and 576, but it is there, my lord. I have found it. So much of documents. There, I'm finding it. Then ultimately, my lord, inquiry report is submitted, which your lordship finds at 569. Enquiry officer finds him guilty. Just to appreciate matter, I think we have to read the enquiry report also.
Day after tomorrow.
I think it will be better day after tomorrow. Day after tomorrow.
Day after tomorrow.
Yeah. Day after tomorrow. Yeah.
So, this honorable court also gave the opportunity to submit the document regarding then because the senior counsel is the submission by
You raise these issues on when you get your chance to reply.
no, Lordship, before their submission, I need to keep the details. That is why if I could not submit the issue, the submission of the learned counsel is totally misleading because Lordship does
Let him complete the submission.
the
Why-
15th
why are you
Lordship,
interrupting?
he could not
This way
mention
we can't continue hearing, Mr. Bora.
he could not
Whatever it may be, let him
con-
submit.
he could
You
not
get your-
maintain his sequence, Lordship. He himself on 15/10/2022, my letter was
Here-
completely sent for consideration. My application. He skipped the.
You will get your chance to reply.
Lordship, after I replied, then if they could not, they did not respond my submission, then how can I defend myself? First, allow if they will going to submit details, Lordship, then finally give me an opportunity to submit the details. Then after my submission, kindly allow them to respond. Then only I
What details you want?
Lordship, they are raising issue that I mentioned that mentioned about the facility
You
of the
completed your submission, then therefore we asked them to
no,
reply.
Lordship, I did not complete my
Then why did you sit down?
No, Lordship, I am just because in last occasion, earlier occasion, this honorable court give me only 10 minutes, and this court will rise up before 4. That
You
is
have
why
a problem with everything, then we can't help it. No? If you have a
Lordship,
problem with the
kindly
court
give me
also,
an opportunity, Lordship.
what opportunity do you want?
I kindly allow me an
We
opportunity.
have understood. What is your challenge in the writ petition?
Sir, my challenge
What is your challenge in the
my
writ petition?
challenge is very simple, Lordship.
What is that?
First, that the transfer order was violated by themselves. Therefore, they.
What is your challenge? What is your prayer in the writ petition?
I'm coming to the point, Lordship. Transfer order, by violating the transfer order, they.
Are you challenging the transfer order?
No, that transfer order.
Are you challenging the
no,
transfer
because,
order?
Because the transfer order was.
We are
already-
asking you a question, give us a direct reply.
No,
Are you
Lordship, I did
challenging
not
the transfer order?
violated the transfer. Okay, to challenge the transfer order because transfer orders are already violated, already make
Are you
unenforceable.
challenging it in the writ petition or not?
I am not. I did not challenge because.
Exactly. So what are you challenging is the departmental proceeding.
No, Lordship, I challenge the every document that they issued by violating the transfer order because that is a broken foundation. They cannot legalize their illegal act by using stop.
This way we can't continue hearing.
Lordship, kindly allow me to.
No, we'll not allow you now.